One.
Good morning, ladies and gentlemen. Welcome to the January 22, 2025 meeting of the Board of Oil, Gas, and Mining here at the Salt Lake City office. We have a few people participating online. Is our director online yet?
Yes, Chairman, I'm available.
Okay. We are ready to proceed, Mick.
Thank you.
If you'd like to go ahead with the informal issues.
Certainly will. Thank you so much, Chairman and members of the board. And again, my apologies for being remote today. I seem to have contracted something that put me home, but I think it's better for everyone. So we'll move forward with the briefing update.
Mick, could you turn your camera on? Or are you going to go without a camera?
No, not going to be a camera, Matt.
Okay, no problem. No problem. Thank you.
Certainly. I want to keep people in the meeting. But thank you. Regarding the board processes update, as you may recall, the division contracted with Third Wind Leadership last year to evaluate board process improvement options. That's gone well. They reached out to a number of stakeholders over the fall, and they're getting ready to initiate workshops covering two different workshops, board policies and processes. And the second workshop is going to be for administrative and information processes. We anticipate Third Wind will have 2 to 4 workshops that should be wrapped up by the end of March. And some indication of the content. As they were interviewing stakeholders, it helped them build an agenda and topics for those workshops. I have not seen the agenda yet, but I've got good confidence in Third Wind. I'm not certain what point board members will be involved in that, although I'm certain they will at some point. But just to let you know that that's moving forward. Any questions regarding board processes before we move on?
I think we're
okay.
good.
Thank you. Update on board member vacancies. We had about 3 applicants for new board members last month. The division recommended Patrick James to the governor's office. The governor's office has tentatively accepted that, and we're in a 30-day comment period currently. We anticipate that the appointment will be finalized by the end of February. And then Mr. James, if selected, will be our mining expert beginning in the March meeting.
Will that work into, because he's got to have Senate approval too, does that work into the same time schedule that he'll be available March 1st? I guess it's sort of dependent on.
A good question. I'll check on that. I think, I'll check on it. I have seen other times where the Senate approval can come post-appointment, depending on the availability of the Senate, but they may put it through while, obviously, in February preemptively. So let me check on that, Chairman. That's a good question.
Yeah, if you would, because he probably can't vote or anything until he's confirmed by the Senate.
Very good.
Anyway, if you could check on that, that would be great.
I will. Definitely will. Thank you. The third item on the agenda, the status of oil and gas bonding rule. Briefly, some background. I guess sometime in 2019, the legislature charged the division and to modernize our oil and gas bonding amounts for operators. Since that time, over the past nearly 5 years, the division has worked pretty consistently with operators to try to develop an updated bonding scheme that protects the citizens of Utah while also enabling a good, robust industry. And we've reached a point where we have some draft versions out there. I think industry has some draft versions as well. And at this point, we're coming to the board and asking, what does the board recommend as far as next steps? Is there a certain course of action that you'd like for us to follow as we get this across the finish line?
Let me just start, and other board members might have some comments on this also, but the board is just getting its first real view of the rules that have been proposed, both from the division side and from industry side. And I think we're going to want to entertain discussions. This is not something that's going to happen overnight. It's an extremely important rule that we're trying to put into place. And I think we want to, before we make any decisions and commence formal rulemaking, we want to have a lot of informal discussions. And so I think we're going to plan to do that. Let me open it up to the board if you have any comments or concerns or whatever.
Yes, Mick, I really like the idea of having informal discussions prior to entering the formal process, so that we get it in pretty good shape before we enter the formal process and have those time limits and all those things. So I believe we would like to hear on an informal manner from both the division, industry, and also other parties that are, say, on the environmental side or something like that, so that we have some good input before we get to the formal process.
Director Thomas, are you going to be at the February meeting?
Chairman, yes, I will be at the February meeting.
Perhaps at the February meeting, we could request the division to spend some time outlining the rules they have proposed as a basis to get these discussions started. Can we allow for some time to do that? And then, hang on. We'll move on from there to figure out what the next step is. We're doing this kind of one at a time and slowly. Ms. Sierra.
Yeah, I'd kind of like to look at some kind of an analytical view of the impacts to the different, for the division. What does that mean for the division, the stakeholders, and the stakeholders across the board? Not just, I think there's the input that we need to get from everybody. So I'd kind of like to get more of the impacts affecting all the different parties, that those that are going to be implementing the rules, as well as those that are going to have to comply with the rules.
Yeah, I think that's good counsel, and I think we'll start out with the division making their presentation and discussing the things Selma's concerned about, and we'll move into the industry position and other people. I mean, we want to open this up and make sure we've heard from a lot of the parties out there how this affects them in their company, in their business, so that we can come up with a good decision in the end. So, Mr. Thomas, maybe you can get the division started, working on a presentation for the February meeting.
Thank you, Chairman and members of the board. We're well on our way toward that. And as we present in February, we'll have a number of different scenarios that we could present to the board, because you're right, this is a significant change, and it's going to impact some operators in less than maybe others. And I think it's a good idea for us to get all that out front in front of the board sooner than later. So we'll definitely be ready in February to present. Thank you.
Thank you.
One last thing.
Ms. Borden.
I think it would be valuable in February also to have a historical analysis of, and maybe we have enough data to actually make it a statistical analysis of costs when the division has had to take on the responsibility of closing wells versus the bonding, so we can just see what the kind of historical trends have been.
That's a good idea. I think Chairman and Rich will. I think it was Rich. Excuse me. I'm watching on my laptop. We've got that data already, and thankfully Utah, we have had an excellent track record of operators managing these wells. The amount of money we've had to put into plugging and abandoning orphan wells, especially versus other states of similar production, is something to be really proud of. And we'll touch on that next week, or pardon me, in February.
And in the interim, we would welcome any written correspondence, any groups. UPA has submitted comments in the past, and if there are other people who wish to submit comments for us to consider, we would appreciate hearing from all those affected. Anything else? Okay, I think we're ready to move on.
Thank you. The next item is the legislative update, and I'm hoping that Natasha is in the room and ready to present on that.
I am. I'm Natasha Baliff. I'm the Legislative and Policy Coordinator for the division. And today I'm giving a legislative update. It started yesterday, so there's not much. We do have one numbered bill. It's Senate Bill 34. This is Mineral Surety Study. It is sponsored by Senator Darren Owens. And surprisingly, this has already gone all the way through the Senate and is now on the House side. This directs the division to study multiple forms of surety within our minerals program. Let me clarify that. Multiple forms of surety, surety amounts, factors to be considered, surety requirements of others, including other states, appropriate enforcement actions, surety requirements, in other states, sorry, reread that. Address insurance products and captive insurance companies and if they should be used or not, and whether or not a surety pool should be created, and any other issues that the division finds necessary to include in this study. We should be reporting on or before October 2025, the Natural Resources, Agriculture and Environmental Committee meeting. That one, I believe that Mick already has a plan going forward. I'll pause and let him speak up if he would like to about that. If not, I'll move on.
Thanks, Natasha. We're modernizing bonding on the mining side. There is financial assurance vehicles have changed. I think it's appropriate for the state of Utah to accommodate those new changes in vehicles. And this is just an initial study to see what could work within Utah and wouldn't. So thanks, Natasha. You covered it really well.
Thank you. Just read the bill language. We do have a watch list of bills that we're anticipating to come out. We do anticipate something about brine legislation coming out. That would be a follow-up to House Bill 433 from last year. We're anticipating the aggregate study follow-up. So that one will be follow-up to House Bill 502. I believe it was titled Critical Infrastructure Material. That one we just gave the final report to the legislature and it was approved yesterday, I believe. So that is available publicly through the legislative website. We also have a bill coming out for environmental litigation bond. I believe Deputy Director Dana Dean briefed the board on it in the last couple of months. This one was something that was put in place 14 years ago and was never utilized, and now I believe it's SMACRA is coming back and saying that we need to have our coal program removed from it so we can keep primacy of the coal program. So that's something that we're anticipating language to come out soon. We do have Representative Colin Jack sponsoring that bill. And then we also have been talking to Representative Christine Watkins, about adding penalties to our Class 6 statute. That is a requirement to get primacy from the EPA, so hopefully that goes through this year. But that's it on my watch list. You should anticipate weekly emails from me. Those usually go out Friday morning. If you have any questions, feel free to reach out to me. I'm happy to answer anything. I think the last thing that I will say is tomorrow, our division is presenting in front of the Natural Resources Committee. If you want to watch, that's available online. You can find it through the legislative site, and if not, feel free to email me and I can pass along the link.
What time is that hearing, do you know?
It starts, I believe, at 7:45. We're later on the agenda. I'm guessing 10 a.m. and after.
And that's tomorrow.
That's tomorrow morning, yep.
Anything else?
Nope, that's it for me, unless you guys have any other questions.
Well, it's simple so far
Yes.
on day
Yes.
2.
Yes, we're only on day 2.
Thank you, Natasha.
You're welcome.
Mick, do you have anything else?
Not really. Thank you, Chairman. And again, good on Natasha. She did a great job laying it out. And this is her busy season. Over the next 7 weeks, she doesn't take vacation during this session. That's for certain. So we really appreciate what she's doing. I'll just move on to next month's agenda. Our next meeting will be Wednesday, February 26th at 9 a.m. I think you already alluded to that. And we're working through the dockets for those right now. So that's all I have. If you have any questions, Chairman, or any member of the board, I'm happy to help.
Board, do we have other questions?
Yes.
Mr. Church?
Yes, Director Thomas, I'm interested in the directive that the governor gave at the first of the year for the division to streamline the permitting process, and has asked for an interim report and then a final report this year. Is that something the division has already undertaken or is planning to undertake?
Chairman, Member Church, thank you. That's a good question. And it's interesting the amount of questions we've gotten regarding that executive order. So I can touch on it briefly. The division is going to is evaluating our permitting processes to see if any current permits could be done by permit by rule, which is what the executive order called for. As I read the tea leaves a little bit, I think the main thrust of this executive order was directed toward the Department of Environmental Quality, specifically some of their air quality permit approvals and issuances. But we're happy that the division was also called into it. So the division is, especially on the mining side, evaluating potential permitting processes that could be changed to be permit by rule. Maybe some of the small mines, for example, but that's very speculative. So far, we haven't done a whole lot of work on that yet, but I hope that helps a little bit. Thank you, Chairman and Mr. Church.
Thank you.
Board, do you have any other comments? Mr. Walker?
Yes, Mick, as you're preparing for this presentation in February on the bonding thing, I think it'd be very illustrative for the board to see where the state of Utah stands in comparison to other agencies in the nation. For instance, our industry and the division have done a really good job on keeping orphan wells and abandoned, those sorts of things from getting out of hand, so that such our liability is not huge at this point in time when compared with other states that have, tens of thousands and billions of dollars of liability. So let's get if we could have some of that data to illustrate that where Utah stands comparative to other state agencies would be helpful, I think.
Thank you, Chairman. Vice Chairman Walker. We agree. We have already began looking at some of the data, for example, Oklahoma, Texas, and on the other side, Colorado and California, right? And seeing where we kind of mix in. It is a challenge, to be honest, because it's an apples and orange comparison, because each state has different structures based on whatever the legislature put in place, at that time. But we are digging into that. We did a little bit, I think, October, November last year, and got some initial results, and we'll open that back up now.
Any other comments? We now have an opportunity for public comment. If there's anyone in the audience, Ms. Harinko Browning.
Ms. Chairman and Board, thank you very much.
Would you introduce yourself first?
Yes, my name is Ricky Renko Browning. I'm president of the Utah Petroleum Association. Thank you for the opportunity to share some comments and thoughts today. I did want to provide a little bit of feedback on the bonding rule that was discussed just a few moments ago. We certainly appreciate the need for the state to update bonding regulations. We are also very appreciative of the multi-year process and the amount of energy and time that the division and industry has put into this process. However, we're now several years down the road. And at this point, industry does have some very significant concerns with the proposal and the structure that has been put out, as well as some very real potential financial strains to operators. Just as background, UPA sent its most recent red lines to the board on January 12th. We also sent those to the division. We had sent a prior version of red lines against the division's draft in August as well, and the latest draft that we are aware of from the division is dated as of July. A number of the comments that are in both our August and our January red line are issues that have been longstanding and not yet addressed by the division. So do understand the need to perhaps elevate this to the board to try and get some resolution on areas where we have not been able to make progress. While I understand that your action today is just notifying parties that this process is going to start and that the board is going to be more directly engaged in leading that process, I did want to just flag some specific thoughts as you enter into this process, which address some of the comments that came up today in your discussion. So just as an example, I wanted to give Operator A. I won't identify them yet, but I'm going to call them Operator A. Operator A currently holds $1 million in bonding with the state of Utah. If the division's July proposal were to move forward as currently drafted, they would be facing a 180% increase in their bonding liability, 180%. To further put that into perspective, we talked a little bit about Colorado this morning. Colorado also recently went through a very significant bond restructuring process, and Colorado is well known to have extremely stringent regulations, and in some cases, those have actually been detrimental to industry and driven some companies out of the state. Operator A happens to have wells both in Colorado and in Utah. They've got almost 3,900 wells in Utah and about 4,900 wells in Colorado. As a comparison, even though this operator has about 1,000 wells less in the state of Utah, they would be paying almost the same amount as they do in Colorado if the division's rules were to move forward, despite the fact that they have 1,000 less wells. So that flags concern for us that the current draft is going to be at least, if not more, onerous than the bonding format that has been put out in the state of Colorado recently. I also want to flag that while UPA covers or has members that represent the majority of operators, there are certainly smaller operators that are not our members. There are operators outside of the Uinta Basin that are not our members. And so our comments are not necessarily reflective of the entire industry. And I share the concern about what these bonding rules would mean for some of the smaller operators that are not UPA members. Those are operators that are likely unaware of the current status and the multi-year process that has been going on. They also are operators that may not have the financial resources to have legal counsel to engage in this process in front of the board, which is a requirement. So I'm not sure how to address that, but did just want to flag it as a point of concern. We have sent a number of questions similar to what several of you asked today to the division to better understand the amount of funding that the division has had to spend on abandoned wells in the past and how much of that has come from bonding that operators have held versus true liability to the state. We're eager to see what that looks like. We have also asked a question as to how much revenue this new bonding proposal would bring for the state. As was mentioned, Utah has actually one of the smallest orphaned and abandoned well counts of all states. We're very proud of that. We simply do not have a significant orphaned well problem. On the other hand, overbonding does tie up precious capital that cannot be deployed back into wells. It's not invested into air emission reductions. It's not invested into the infrastructure needs that are necessary to continue to grow the basin, and can have very real negative impacts in terms of overbonding to revenues back to the state, in terms of jobs, in terms of production growth, and efficient utilization of the resource. And so, again, while we understand the need to update these rules, we also just want to make sure that the board is aware that there are a number of concurrent financial requests or needs or requirements that are layered onto the industry at the same time right now. This bonding rule being one of those. We are dealing with a significant road fee in Duchesne County, where the majority of the production is based, that comes with a very large price tag. There is a bill, Natasha didn't mention this because it's not yet public, that Senator Winterton is considering to bring forward, that would be a new production tax that would be very significant on the industry. And there are some tribal ordinances that also have large price tags, in addition to a number of recent federal rules and requirements with significant price tags. All of these costs add up. And if the return on capital is better in other basins than it is on wells here in the state of Utah, that capital will be reallocated to those other basins. It's a very real issue. We've seen it in some of the recent transactions that have just happened, and we have to be very careful and thoughtful about the financial burden that we are cumulatively putting on wells in the state of Utah. So my ask today would just be that the board carefully considers right-sizing these rules, that how we have a good understanding as to what the state's liability is, what the revenue generation would be, and what the implication is to a range of different operator types, whether those are large, medium, or small, whether those are primarily gas or oil. There are very significant differences in the impact to operators, and I would just ask very careful consideration that we are right-sizing these rules to address the actual liability the state faces. And we look forward to working together through this process. Thank you.
Thank you for your comments. They're appreciated. You know, and part of the reason for involving the board now is to try to pick up on some of those small operators and give them a voice, if they choose to have it, to participate in this rulemaking. This makes it a little bit more public out there with information. But we look forward to working with you and the other operators out there to resolve this issue after many years. Thank you so much. Do we have any other public comments? Seeing none, you may notice that we no longer have a court reporter in the room. We are going with the digital recordings of these meetings as our permanent record. Swearing in at these meetings will now be done by the vice chair, unless he or she is unavailable, and then the chairman will do it. But I think we're ready to proceed directly into the formal part of the session. We have several hearing examiner matters to handle. I think we're ready to proceed here. Docket number 1. Docket number 2025-002, cause number 132-66. In the matter of the request for agency action of OVINTIV, consenting owners in the Beale, Utah 13-34, 4-3-3-10-7H well, in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations, comprised of sections 3 and 10, 4 South, 3 West, USM, Duchesne County. Introduction of participants here.
Fred McDonald of Counsel with Lear & Lear on behalf of petitioner OVINTIV USA Inc.
Thank you.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you.
John Rogers, Environmental Manager with the Division of Oil, Gas, and Mining, acted as hearing officer.
Thank you.
Assistant Attorney General Gary White, counsel for the hearing examiner.
Thank you. Would you please proceed with the report?
Thank you, Chairman Garrison. I acted as a hearing examiner in this proceeding as directed by this board. The proceeding was held with an anchor position in the Department of Natural Resource Building in Salt Lake City, Utah on Wednesday, January 15th, 2025. During the proceeding, 2 sworn declarations and exhibits were admitted into evidence on behalf of OVINTIV from Mr. Ashley Ellison, a senior land negotiator, and Mr. Christopher Wall, a senior reservoir engineer, both from OVINTIV. These declarations were reviewed by me prior to the hearing. Mr. Fred McDonald was present at the hearing and acted as counsel for OVINTIV. Mr. Andrew Haynes was present at the hearing for the division, and Mr. Gary White of the Attorney General's office represented me at the hearing. Both of OVINTIV's witnesses were accepted by me and the division as expert witnesses in their field of work for this matter. They also presented live testimony electronically in the hearing. The division filed a response of non-opposition to the request for agency action dated January 8, 2025. At the conclusion of the hearing, Mr. Haney, on behalf of the division, stated support for the request for agency action. The Division of Oil, Gas, and Mining and I had the opportunity to cross-examine the witnesses presented on behalf of OVINTIV. After reviewing the request for agency action, the sworn declarations, and admitted exhibits, and hearing live testimony presented at the hearing, I found and recommended the following. OVINTIV provided sufficient and adequate notice of opportunity to the parties it was seeking to compulsory pull. Proper notice for the hearing examiner's proceeding was also provided. Those owners that failed to participate timely should therefore be considered non-consenting parties. The proposed JOA includes terms that are just and reasonable, and it should therefore be adopted to govern the future dealings with the parties. The 300% non-consent penalty is fair and justified given the economic and geological conditions present in connection with the drilling of this well. I therefore recommend that the 300% non-consent penalty be imposed as requested. OVINTIV has met its burden of proof and otherwise satisfied all legal requirements to the compulsory pooling of the non-consenting parties. For your interest, OVINTIV's working interest is 76.511%, non-operating working interest is 21.78%, and the compulsory pooled interest is 1.71%. The average weighted fee landowner royalty interest was approximately 18.44%. OVINTIV's counsel, Mr. Fred McDonald, prepared the proposed finding of fact, conclusion of law, and order granting its request for agency action. Both the division I reviewed and approved the order. I then executed the proposed order and filed it with the board's legal assistant. It should now be ready for the board's review and execution. I'll take any questions at this time.
Mr. McDonald, do you have any questions or comments?
No, again, matter went very smoothly. Appreciate Mr. Rogers' time. We would ask that the board approve the order as submitted. And again, we thank the IT group as well for allowing the virtual participation. Mr. Ellison and Mr. Wall are both available virtually this morning in case the board had additional questions.
Mr. Haynes.
Yeah, as stated, the division reviewed the finding of facts, conclusion of law, and we approved of it. And as we stated in the hearing examiner proceeding, we feel that the petitioner met the statutory and regulatory obligations.
Thank you. Board, do you have questions or concerns? Are we ready for a motion? Mr. Church.
Yes, Madam Chair, I move that we approve the RAA as submitted.
Second? I'll second that. It's been moved and seconded. All in favor, please say aye. 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 Those opposed? Please note the order passes. And we will get that order signed into you.
Thank you.
Thank you. Moving on to docket item number 2. Docket number 2025-003, cause number 132-67. In the matter of the request for agency action of OVINTIV USA INC for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Spear, Utah 4-26, 3-2-26-35-17H well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations in sections 26 and 35, 3 South, 2 West, USM, Duchesne County, Utah. Introductions, please.
Fred McDonald of Counsel with Lear & Lear on behalf of petitioner OVINTIV USA Inc.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
John Rogers, Environmental Manager with the Division of Oil, Gas, and Mining, and I acted as hearing examiner in this matter.
Assistant Attorney General Gary White, counsel for the hearing examiner.
Thank you. Please proceed.
Thank you, Chairman. The proceeding was held with an anchor position in the Department of Natural Resource Building in Salt Lake City, Utah on Wednesday, January 15th, 2025. During the proceeding, 2 sworn declarations and exhibits were admitted into evidence on behalf of OVINTIV from Mr. Peter Burns, a land advisor, and Mr. Christopher Wall, a senior reservoir engineer, both of OVINTIV. These declarations were received by me prior to the hearing. Mr. Fred McDonald was present at the hearing and acted as counsel for OVINTIV. Mr. Andrew Haynes was present at the hearing representing the division. Mr. Gary White was Attorney General's office, who represented me as a hearing officer. Both of OVINTIV's witnesses were accepted by me and the division as expert witnesses in the field for this matter. They also presented live testimony during the hearing. Prior to the hearing, there were 2 objections received by the division. One from Julie Ann Mosquedo and Kimberly Richens filed timely objections on January 6th and January 8th, respectively. The objections were resolved on January 10th and were withdrawn. I may defer to Mr. McDonald at this time to state how those were handled and what came about on those.
Yes, I'll be happy to answer that. As far as the situation was, again, the objectioners did not understand that they were already leased and voluntarily pooled. They asked for certain information, which both OVINTIV and myself provided to them. Both parties were very satisfied with that and filed formal withdrawals of their objection prior to the hearing.
Okay, thank you. The division filed a response of notice of non-opposition to the request for agency action dated January 8th, 2025, based on the resolution of the previously mentioned objections. At the conclusion of the hearing, Mr. Haney, on behalf of the division, stated support for the request for agency action. Other than the previous settled objections, no other parties filed a response to the request for agency action or appeared at the hearing. The Division of Oil, Gas, and Mining and I had the opportunity to cross-examine the witnesses present on behalf of OVINTIV. After reviewing the request for agency action, the sworn declarations, and admitted exhibits, and hearing live testimony presented at the hearing, I found and recommend the following. OVINTIV provided sufficient adequate notice of opportunity to the parties that was seeking to compulsory pool. Proper notice for the hearing examiner's proceeding was also provided. Those owners that failed to participate timely should therefore be considered to be non-consenting parties. The proposed JOA includes terms that are just and reasonable, and it should be therefore be adopted to govern the future dealings between the parties. The 300% non-consent penalty is fair and justified given the economic and geologic conditions present in the connection with the drilling of this well. I therefore recommend that the 300% non-consent penalty be imposed as requested. OVINTIV has met its burden of proof and otherwise satisfied all legal requirements to compulsory pool the non-consenting parties. For your interest, OVINTIV's working interest is 99.49%. Non-operating working interest is 0.038. UDOT has an interest that has been voluntarily pooled at 0.378%. And at this time, I'd just like to note, Mr. McDonald, could you explain how that worked in here, what the situation between FS, the Fire, Forest, and State Lands, and UDOT works out?
Yes, Forestry, Fire, and State Lands by statute is the administrative agency that governs for the Department of Transportation. There are highways that run through here that they own the fee minerals in as well. OVINTIV has for about a year and a half nominated those parcels for leasing, and it still hasn't been offered yet, although we understand that will be forthcoming. There was some question about whether or not UDOT could be force pooled. So with discussions with the Forestry, Fire, and State Land Council, we came to an agreement that they would ratify the pooling declaration and thereby voluntarily pool their interest, and then it will be dealt with once a lease is issued. From OVINTIV's standpoint, the revenue attributable to those lands has been held in suspense as required by statute and will be released once the leasing situation is resolved.
Thank you, Mr. McDonald. The average weighted fee landowner royalty interest is approximately 18.0695. OVINTIV's counsel, Mr. McDonald, prepared a proposed finding of fact, conclusion of law, and order granting its request for agency action. Both the division I reviewed and approved the proposed order. I then executed the proposed order and filed it with the board legal assistant. It should be now ready for the board's review and execution. I'll take any questions at this time.
Mr. McDonald, do you have any further comments?
No, Madam Chair, other than, again, to thank Mr. Rogers for his time. Mr. Burns and Mr. Wall, again, are both virtually here in case the board had any questions. We believe that everything's been satisfied and would request that the board approve the request and the order is submitted. And again, we thank the IT people for allowing the virtual participation of the witnesses.
Thank you. Mr. Haynes?
Yeah, no additional comment. The division felt that the petitioner met the statutory and regulatory requirements. Our initial opposition as to the oppositions that were filed were satisfied, and so we had no further objection.
Thank you. Board, do you have questions or comments? Mr. Church?
Yes, Mr. McDonald, in the very unlikely case that OVINTIV is not a successful leaser of that UDOT acreage, the winner of that lease then will come in as a working interest owner in the well. Is that correct?
That's correct.
With no penalty?
That's correct.
Okay, thank you.
Mr. Walker?
Yeah, and I missed the, what is the percentage for compulsory pooled at this point in time then?
It's 0.091804.
Thank you.
Board, do you have other comments? Seeing none, do I have a motion?
I would move that we approve the hearing examiner's recommendation.
I second.
It's been moved and seconded. All in favor, please say aye.
Aye.
Any opposed? Please note it carries. We will get that order signed and over to you.
Thank you.
Good morning.
Good morning, Madam
We
Chair.
have a new attorney.
We do. Mitch Mayo of Lear & Lear on behalf of the petitioner OVINTIV USA.
We're going to move on to docket item number 3. Docket number 2025-008, cause number 132-70. In the matter of the request for agency action of OVINTIV USA Inc. for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Mamie, Utah 4-25, 3-3-25-36-46-46H well, identified herein in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations in sections 25 and 36, 3 South, 3 West, USM, Duchesne County, Utah. Appearance.
Thank
Intros.
you, Madam Chair. Mitch Mayo of Lear & Lear, PLLC, on behalf of the petitioner OVINTIV USA Inc.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
John Rogers, Environmental Manager with the Division of Oil, Gas, and Mining, and I acted as the hearing officer in this matter.
Assistant Attorney General Gary White for the hearing examiner.
Thank you. Mr. Rogers, please
Thank you.
commence.
The proceeding was held with an anchor position in the Department of Natural Resource Building in Salt Lake City, Utah on Wednesday, January 15th, 2025. A unique situation concerning this hearing I'd like to address at this time. An affidavit from the Uinta Basin Standard Examiner was received, and the timing of the release of the notification of this was problematic. The notification was to be on December 18th and the 25th. The 25th, on the 18th, the notice was put in the newspaper. But through problems at the Standard Examiner, on the 25th, it was not put in. So we missed our deadlines there. So they then published January 8th and January 15th. The 15th was the day of the hearing. So the problem there is it states in statute that the notice has to be 2 weeks, 2 consecutive weeks prior to the hearing. So we went ahead with the hearing at that time based on our decision to be provisional of what would happen if we went ahead. So this time we need to decide if something's going to come through in this meantime, any objections. If not, then obviously we could provisionally approve this. I'd like to turn some time over to Mitch Mail to see what deadline we should put out there for this to wait until we can approve this order.
Yeah, thank you. Madam Chair, member of the board, a couple things first. It is a unique issue that's arrived, and I know the board is sensitive that hearing examiner matters don't involve anything new or novel. To be clear, this is something that has happened before the board and has been addressed in a very similar fashion today, so I feel like it still respects the board's request that those hearing examiner matters be held in a way that has already been tested by this board. That being said, Mr. Rogers hit it on the head. Uinta Basin Standard, for some reason, had a computer glitch, and several of the publications didn't go out as expected. They were supposed to go out on the 18th and Christmas Day, the 25th. For some reason, the 25th didn't get published, and we didn't find out about this until January 7th, the day before the division had to file its response. And so through a series of trying to solve this as quickly and seamlessly as possible, we essentially came up with the notion of presenting all of the evidence at the hearing examiner hearing. I made an oral motion to continue under the rules, essentially hear the evidence, make the determination whether we've met the evidentiary standard, but don't sign the order until the February hearing so that anyone who receives notice, if they're concerned, can come forward at the February hearing and raise those concerns, and the order can be modified accordingly. So essentially, to respect the hearing examiner process and the schedule, we tried to get the information on the record and approved, but the board won't be considering an order here today for that. That motion was granted by the hearing examiner during the hearing, so I'm not sure that it needs to be even granted here, but the rules do say that a continuance will be noted on the record.
So are we doing a conditional approval, or we are holding off our approval until February?
I don't think it's up to the board. The order that's drafted currently has placeholder language for what will happen at the February hearing. So I don't have a written order that would be really easy for the board to execute today. The hearing examiner has approved it, subject to the continuance and essentially presenting the recommendations at the February hearing that he would have presented today.
Okay.
So I would say just a continuance on the record. It doesn't need to be recalendared on the hearing examiner hearing, but it will need to be docketed for the February 26th hearing so that we can do what we're doing now at that hearing and finalize it.
Okay, now we're going to hear the findings of the hearing examiner. Is that correct?
Yeah. That's my thought.
Okay.
Yep.
Okay, let's move ahead.
Thank you.
Just for your information, I will not be present at the hearing next month, so just so you're aware of that. I'll present here, and then we'll probably have either another representative legally just go on with that, if that's all right.
Okay, yeah, that's fine.
Okay. Okay, with that behind us, we can go ahead. Okay. And one thing I would want to add, though, once the order is received, if the division or we won't receive that till when?
Excuse me, I emailed a draft that's not ready to be a draft last night to council here and to the hearing examiner so they could at least see the thought process on how to resolve this at the February hearing. My estimation would be after 30 days expiration from the last published notice. The last published notice in the 2 consecutive week cycle was January 15th, so I would say February 15th would be the appropriate day to circulate that order and have Mr. Rogers and the division and Gary, Mr. White, Mr. Haynes weigh in on any changes to that order. So between the 16th of February and the 26th of February, the board will have the finalized draft ready for entry at that February hearing.
And Mr. Mayor, my only problem with that is I will not be available at that time. So how would we handle that? Could we get it any earlier than that, or is that not?
As I said, the only parts that aren't complete are the parts that I won't know by the time you leave, it sounds like, because the February hearing won't have happened. So I'll have placeholders if council's able, or if Mr. Boz is able to approve those portions that are kind of in dispute until the February hearing. Like, for example, no one appeared at the February hearing and objected. We don't know that yet, but it's in there as placeholder language for the possibility. And so if Mr. White can confirm that fact on the record, I think we should be okay.
I don't think it'll be a problem for us to make those arrangements.
Thank you. Let's proceed with the testimony.
Okay, I just want to be upfront with that so you knew.
Sure.
Okay, thank you.
Thank you.
During the proceeding, 2 sworn declarations and exhibits were admitted into evidence on behalf of OVINTIV from Mr. David Dale, manager, Rockies Land, and Mr. Christopher Wall, a senior reservoir engineer, both from OVINTIV. These declarations were reviewed by me prior to the hearing. Mr. Mayo was present at the hearing and acted as counsel for OVINTIV. Mr. Andrew Haynes was present at the hearing representing the division. Mr. Gary White of the Attorney General's office represented me at the hearing. Both OVINTIV's witnesses were accepted by me and the division as expert witnesses in their field of work for this matter. They also presented live testimony electronically in the hearing. The division filed a responsive notice of non-opposition to the request for agency action dated January 8th, 2025, based on the resolution of the previously mentioned noticing issues. At the conclusion of the hearing, Mr. Haynes, on behalf of the division, stated support for the request for agency action with the exception of noticing issues previously mentioned. The Division of Oil, Gas, and Mining and I had opportunity to cross-examine the witnesses present and on behalf of OVINTIV. After reviewing the request for agency action, the sworn declarations, and admitted exhibits, and hearing the live testimony presented at the hearing, I found and recommend the following. Approval of noticing, hearing examiner proceeding, and those owners that failed to participate timely should therefore be considered non-consenting parties only if they do not respond by February, as we noted in the next hearing. OVINTIV provided sufficient adequate notice of opportunity to the parties it was seeking to compulsory pull with the notice issuing previously mentioned, but must wait until February 15th, 2025 to see if any owners respond. The proposed JOA includes terms that are just and reasonable, and it should therefore be adopted to govern the future dealings with the parties. The 300% non-consent penalty is fair and justified, given the economic and geological conditions present in connection with the drilling of this well. I therefore recommend a 300% non-consent penalty be imposed as requested. OVINTIV has met its burden of proof and otherwise satisfied all legal requirements to compulsory pull provisionally if no one responds by February 15, 2025. For your interest, OVINTIV's working interest is 76.511%. Non-operating working interest is 21.78, and compulsory pulled interest 1.71. Excuse me, I just want to double check those figures. Yeah. I made a mistake on those out from the previous one. Apologize for that. These start blending together after a while. So let me read those again. OVINTIV is 99.50% for working interest. Compulsory pooled interest is 0.4985, eating 100% there. Okay, I apologize for that. The average weighted landowner royalty interest was approximately, let me double check that one here. Okay, I have down as 18.44. Is that correct, Mr.? I think I got a typo in here.
Let me see, I can get you an answer quick.
Yeah, I don't think that's right.
Yeah, I think I have the exhibit from the previous one. $18.692766.
That's it.
I'm sorry, after these start blending together. Apologize for that. OVINTIV counsel, Mr. Mayo, as we discussed, has not prepared a finding of facts and order yet. They'll be waiting on that next month as we get the final options of if someone does object. At that time, we'll follow through with the executive executed proposed order and file with the board's legal secretary at that time. At this time, I'll take any questions you have any concerning this matter.
Mr. Mayo?
You know, I wish we had, they were all seamless. Sometimes there's confusion. This one and actually the next three are going to have the publication issue. But I think we've done a good job of essentially balancing the needs of the board and the hearing examiner and making sure these hearings happen and they happen as seamlessly as possible for division staff and board staff, but also making sure that there's open time to object, right? The point of this is public notice and for people to come in and voice any concerns they have. So by continuing, I think we've essentially considered the evidence, we're ready to go, and people will have ample time to object should they choose to at the February hearing. So no further comments than that, Madam Chair.
Mr. Haynes?
Yeah, so when the division filed their response, we indicated that the regulatory requirements were not met due to the publishing error. However, as you've heard today, what was proposed here, the division approves of waiting until February 15th to have the final order submitted. And at that time, once we've have the final order and we understand if there's no objections, then we'll offer our approval then.
Thank you. Board, do you have any questions for this witness? Mr. Moon?
So a curiosity question for OVINTIV. Looking at Exhibit 6, there's an older well. Before the 2-mile horizontal was drilled, there's two 1-mile horizontals. And the one in Section 36 has a curious bend in it. The wellbore starts south and then it bends quite a bit to the east and then back to the south. And it appears to be that's under Lake Borum, bending around under Lake Borum. I was just curious if that's the reason for that. Doesn't relate to the forced pooling, but it just wanted to know.
No, it's a really good question. That is most likely related to the lake. I think that's called the Lake Borum well, if I'm not mistaken. So,
but why is there a concern going?
You know, that I'm not sure. I don't know if it was a drilling issue. I don't know if Mr. Burns is covering for Mr. Dale. David. Oh, there you go. David and Christopher here. Maybe they can give you a little.
Mr. Mayo, do we have to swear in the witnesses if they're going to testify?
Since this isn't related to the request, I don't think it's necessary.
Thank you.
This is just curiosity, I think.
Thank you.
Yep.
Please proceed.
Any comment I have would be speculative, although I have my speculations as to why it's that way, but I think Chris is the more qualified person to answer the question.
Okay, thank you, David. So the reason why you see that bend is what the operator was trying to do, or OVINTIV at the time. Actually, it wasn't OVINTIV who drilled it. It's Newfield before them. Regardless, the idea there is they're trying to get it onto a particular slot. That's what we call it. So a particular distance away from the edge of the section there. Looks like this was about 660. So why they put that curve, probably one of the newer wells in the section, and not it could have to do with subsurface easements not being allowed to penetrate certain areas. Define how the well path is drawn out and determined and actually drilled. So there could be several reasons. I don't know exactly why this one has that curvature. Versus some of them usually look a bit sharper of a turn. This one's definitely more gentle. So it could be just a driller's preference as well.
Okay,
Sorry.
yeah, it's a pretty old well. I didn't look up how old it was, but yeah, it's way back when Newfield was drilling 1-mile horizontals. Then just an interesting note, I was looking at the Moon Lake Water Users has 455 acres in that section. And I don't know exactly who that is, but I'm curious. That's a large holding for a water users association.
That's really
to have. So they've had a little extra funds. Hopefully they reduce their water fees. So.
Board, do you have any further questions? Okay, I guess this does not call for a motion at this point.
No, the rule says that a continuance shall be noted on the record.
We've heard the testimony, and we will now continue this matter until the February 26th hearing for final approval by the board.
One last thing, that the continuance rule clarifies that notice need not be done. The board doesn't need to republish notice for the February hearing, and OVINTIV doesn't. I just wanted to make sure the board was aware of that and comfortable with that in this case.
Is everyone? Yeah, we are comfortable with that. Thank you for pointing it out, and it will be noted in the record.
Thank you so much, Madam Chair.
Thank you. All right, that concludes that docket. We are now moving on to docket number 5, and we'll wait for everyone to get. I'm sorry, docket number 4. I'm trying to rush this along.
Well, this one should be faster.
This won't take long.
Yeah.
Okay. Docket number 2025-010, cause number 132-71. In the matter of the request for agency action of OVINTIV USA Inc. for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Peckovitz, Utah 1-14, 4-3-11-2-1H well, in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations, comprised of sections 2 and 11, 4 South, 3 West, USM, Duchesne County, Utah. Appearance, please.
Madam Chair, Mitch Mayo again of Lear & Lear, PLLC, on behalf of the petitioner, OVINTIV USA Inc.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
John Rogers, I'm Environmental Manager with the Division of Oil, Gas, and Mining, and I acted as hearing examiner in this matter.
Assistant Attorney General Gary White, counsel for the hearing examiner.
Thank you. Mr. Rogers, please proceed.
Okay, this proceeding was held in an anchor position in the Department of Natural Resource Building in Salt Lake City, Utah on Wednesday, January 15th, 2025. At the time of the hearing, Mr. Mayo indicated that there were some issues with the matter and requested a continuance to next month's hearing examiner proceedings. I will turn the time over to Mr. Mayo to clarify his request.
Yeah, Madam Chair, this matter had the same notice issue. We were planning on presenting the evidence and doing the same process. However, the morning of the hearing examiner hearing, the witness, Mr. Dale, called and said, in looking at this last minute to kind of finalize my preparations, there may be a question as to that same UDOT DFFSL ownership that Mr. McDonald referenced in an earlier cause. But we had about 30 minutes until our hearing, so we didn't really have time to dig in and conclusively determine that we were okay to move forward. So essentially, we moved for just a straight continuance. We asked that that be placed on the February docket. That night, we resolved the issue, and there wasn't an issue, so unfortunately, it's continued to the February hearing for largely no reason. That being said, there's really nothing we could do except be sure that we were doing the right thing before we moved ahead. So we moved for a continuance, just a straight continuance to the February hearing. I think it'd be appropriate to do that before the board here, since you're not considering recommendations from the hearing examiner. So pursuant to Utah Admin Code R641-105-300, which allows oral motions to be made at the hearing, and Admin Code 641-106-700, which authorizes continuance without renotice. We would move for just a straight continuance of this to the February 19th hearing examiner docket, and also to be approved at the board's February 26th hearing.
Okay, so we are not hearing any testimony today. We're just going to continue the whole matter.
Just a regular old continuance.
All right, then I guess it's up to us to continue this to the February 26th meeting, subject to the appropriate rules.
That's right.
Oh, I'm sorry. Mr. Church has a question.
Mr. Mayo, why would not this be continued to the next hearing examiner?
It is. The hope is that it's continued. The request, if I did it inartfully, I apologize, is to continue it to the February 19th hearing examiner hearing, and for the board's full approval of the recommendations from that at the 26th. One note, Mr. Rogers, who was assigned hearing examiner at this hearing, won't be around to be a hearing examiner at the February hearing. If the board has concerns with that, now is a great time to address it. I don't see any concerns, but...
Well, this hasn't proceeded in any direction, so a new hearing officer won't have any bias.
That's my position as well, Mr. Church. Yeah.
Any other questions? With that clarification, we will continue this matter to the hearing examiner meeting and also to the board on February 26th for final approval.
Thank you. And Madam Chair, since it is technically a motion, I didn't know if a vote needed to happen on the motion for continuance or simply noting it, but just.
We will go ahead and take a vote just to be on the safe side.
Thank you.
Do I hear a motion for continuance?
I move that we continue this till February 19th and 26th.
Second? Second. All in favor?
Aye.
Opposed? Motion carries. We'll see you next month.
Thank you, Madam Chair.
Mr. Mayo? Are you here for the Coastal Plains issue? Are you here for the Alton Coal issue?
I apologize. I plugged in. No, I forgot those two were still on the docket. I
Oh.
apologize.
You had us confused there for a moment.
I'm happy to do it. I just don't know anything about it. So
We're going to move on to
We'll
the
step
Alton
back.
Coal matter. Okay, proceeding on to the next item. Docket number 2024-054, cause number CO250005-COCH 07132024. In the matter of the Alton Coal Development LLC's first amended petition for review of cessation order CH 07132024, Coal Hollow Mine, Kane County, Utah. This matter has been continued from the December 4th, 2024 hearing. Mr. Wright?
Thank you, Madam Chair. Assistant Attorney General Gary White on behalf of the Division of Oil, Gas, and Mining. And my esteemed co-counsel and opposing counsel is not here today because we have reached a settlement in this matter. If the board would like, I can just briefly outline the settlement and
yes,
what we're
please.
trying to do. Okay. So after the prior hearing on December 4th, when the board heard and ruled upon the motion to dismiss filed by the division and Alton Coal entered into settlement negotiations, and we were able to reach a successful settlement. Since settling, we have filed with the board a stipulated motion to dismiss all of the requests for agency action that have been filed by Alton Coal. So you'll see a stipulated motion to dismiss, and we've also submitted a proposed order. All of the settlement terms are outlined in Exhibit A to the stipulated motion. The very basic explanation for the settlement is that Alton Coal, as the board heard in December, is working on bond release. So the division has agreed that while Alton Coal works on bond release up until July of 2025, it will not seek further escalation with regard to further enforcement with regard to the bond escalation issue. So while Alton Coal works on bond escalation, they now have until, I believe the date is July 11th to obtain bond release below what they currently are bonded for. And assuming that they hit that goal, the division and Alton Coal believe they will, then the cessation order will be withdrawn in July. If Alton Coal is unable to successfully obtain the bond release needed, then the cessation order will be escalated. And that's all outlined in the settlement agreement.
And when will we see that?
This will lay dormant until at least the end of July. So I would imagine we would be, assuming that Alton Coal is able to release, obtain the bond release, we should be withdrawing that cessation order by mid-July.
Do you have a copy of the settlement agreement that's going to be filed with the board?
Yes, it's filed as Exhibit A to the stipulated motion.
Oh, okay.
So the entire agreement is there. We hopefully won't need to come before the board again This dismisses all the requests for agency action. All the parties feel that it can be accomplished by those summer dates.
Thank you. Board, do you have any questions before we move on?
Okay, thank you. Happy to do it that way if the board would prefer. It's submitted in writing, but if you'd like to orally rule on it, that would be great as well.
Let's use the oral vote here.
Okay. So the stipulated motion requests that due to the party settlement agreement that docket numbers 2024-054 and 2025-009 be dismissed with prejudice. And that's what we're seeking in the stipulated motion, and there's a draft order that has been submitted.
Do we need a board member to? Can we have a board member approve?
I move that we agree to approve the the stipulated agreement as noted.
A second? Moved and seconded. All in favor, please say aye.
Aye.
Any opposed? Thank you, Mr. White.
Thank you.
Moving on to docket item number 6. Do we have anyone? Okay, so what do we do with this? Must have an old thing here. Docket number 2024-064, cause number 075-04. In the matter of the request for agency action of Coastal Plains Energy, Inc. for an order suspending application of the board's order in cause number 243-1 and 243-4 insofar as they pertain to section 15 and 16, northeast quarter section 21, 22, south half of 23, north half of 27, township 15 south, range 9 east. This matter has been withdrawn. We are now moving on to item number 7, SM Energy. Are we ready to begin? Okay. Docket number 2025-004, cause number 132-68, in the matter of the request for agency action of SM Energy Company for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 2,560-acre or substantial equivalent drilling unit established for the production of oil, gas, and hydrocarbons from the lower Green River, Wasatch, Colton formations, comprised of sections 13, 14, 23, and 24, 2 South, 3 West, USM, Duchesne County, Utah. And can we have appearance of counsel, please?
Yes, Madam Chair. Mitch Mayo of Lear & Lear, PLLC, on behalf of the petitioner, SM Energy Company.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining. And I'm also joined here today by Regina Echo, who is a petroleum engineer with the division, and Colton Goodrich, who is a geologist with the division.
Thank you. Mr. Mayo.
Thank you, Madam Chair, members of the board. I know the board hasn't heard many pooling matters in the last year and a half because the hearing examiner process has worked really well. This board is usually called on to hear complex or complicated pooling matters. I assure you The next two matters are neither complex nor complicated. They are straightforward. But this is SM Energy Company's first time appearing before the board, and I generally think it's best for you guys to have the chance to vet the witnesses the first time in person, at least. Meet them, ask any questions, but really get a sense of them and their credibility in person. So with me here today are Rick Harris. He's the, I'm going to mess up your title, Regional Land Manager for Utah. And Mr. Brad Peterson is also here with me. He is the Region Asset Manager.
Thank you. Can we swear in the witnesses at this time?
That would be perfectly appropriate.
Thank you. We'll have Mr. Walker do that.
Okay.
Please raise your right hands.
Raise your hands.
Do you solemnly swear that the testimony you are about to give in this matter will be the truth, the whole truth, nothing but the truth? So help you God?
Yes, I do.
Thank you.
Thank you.
Thank you for that. Excuse me. To begin with today, I'd like to note the resumes of Mr. Harris and Mr. Peterson have both been submitted as Exhibit 1 in this cause. If asked, they would separately confirm the truth of the contents of those resumes. However, because it's their first time before the board, I will be qualifying or attempting to qualify each of them as experts in their respective fields when I call them to testify. And the board and division obviously will have a chance to vet them during that process as well. Neither witness has appeared before this board or testified before this board. Also consistent with past practices, I will be moving for admission of all of our exhibits at the end of the case in chief. Just for the board's understanding, we've got 2 of these pooling matters in a row and always trying to think ahead to planning. I think we can get these done both before noon for the lunch break. So just if anyone has questions, let us know and we'll slow down where we need to. Again, as I said, although the board hasn't been focused on pooling matters the last year and a half, this cause involves a very straightforward pooling request for a 4-section 2560 well, sometimes called a section line well or a drilling unit boundary well, that produces from sections 13, 14, 23, and 24 in 2 South, 3 West in Duchesne County. I'll probably call that the drilling unit from time to time. The wells at issue produce from the Lower Green River Wasatch formations, the subject formations, as those are more specifically described in the request for agency action. The drilling unit at issue here today was established by the board by order in cause number 600-04 in 2021, as modified subsequently to reduce setbacks in cause 130-21. Collectively, those will be referred to as the current orders. Together, these current orders allow up to 3 horizontal wells, 3 long lateral horizontal wells to be drilled to and produce from the subject formations, so long as each well maintains essentially production setbacks no farther than 560 feet from that center line between the 4 sections and no closer than 100-foot heel-toe production setbacks. A true and correct copy of each of the current orders was also submitted as Exhibits 2 and 3 in this cause. Pursuant to the current orders, XCL, SM's predecessor in interest, drilled and SM now operates the following long lateral horizontal wells at issue here today: the Goose 50-24-23A well and the Goose 70-24-23-23B well. Collectively, these may be referred to as the subject wells. The reason this isn't complicated or confusing, despite the publication issues we talked about earlier, is this request seeks the pooling of only 2 parties, Lloyd Goodrich and Adrian Larson, both of whom have received full valid notice of the election packets and of the request here today, and neither of whom have come forward and commented. Also, collectively, they own in this unit, approximately 0.02% of the unit. A copy of the request, as I said, was mailed certified with return receipts requested to each of these 2 owners. Confirmed receipt is in hand and is included as part of Exhibit 14 in this cause. In addition to these 2 unleased owners, there are approximately 15 estates that will be pooled here today, or that SM is requesting to be pooled here today. SM believes that all of the people claiming interest in these estates have been leased. However, the publication, even when it's flawed, is surprisingly effective. Last night, as I was going through final prep for this hearing, I received a call from a gentleman who was calling because his wife had passed away a decade ago and she was listed on the estates. And so we were able to get that process started despite, mailings for probably a couple years going to his house. This publication and this proceeding, made him reach out and have that call. So, although SM believes all the parties to these estates that inherit are leased and fully committed to this unit, because there are court orders missing, we can't be certain of that fact. So these estates are added out of an abundance of caution. There also, as discussed in the prior causes, there was an unexpected notice problem. As the board's aware, when someone requests pooling and there are unlocatable individuals, the board is presented with an ex parte motion to publish notice, which is routinely granted, essentially allowing that publication so that folks who can't be reached through the mail can have a chance to weigh in. SM undertook the same practice it always does, timely and appropriately sought to publish notice, but due to an unknown error on the publisher's end of things, it wasn't published for the 2 consecutive weeks that the regulations require. The division, rightly in its response, pointed that out and said we can't in good faith say the regulations have been met today. But since discussing with the division offline and also in the ways that the other matters prior to this were handled, it's our position that it's appropriate to do essentially the same thing here today, to make an oral motion under the board's rules for essentially a partial continuance. We ask that the board hear the evidence here today and vet the evidence, but simply hold that order, and we'll do a final signature at the February hearing to ensure that anyone who receives published notice late and would like to comment has that opportunity. And so it's probably appropriate at this time to formally make that motion for continuance under the rules and to ask the board to take a vote on it.
Do I have a motion to continue this to the February meeting
Yes.
for final order?
Madam Chair, I move that we continue this to the February meeting for final order.
It's been moved and seconded. All in favor, please say aye.
Aye.
Opposed? Hearing none, we will continue the matter to the February, or partially continue.
Thank you, Madam Chair. Just to allay the board's concerns, Mr. Harris and Mr. Peterson should both be here in person at the February hearing as well. So if there are any concerns with this, we can clarify those with direct testimony. To be clear, the publication has been effective now. Right, it was flawed December 18th and 25th, but it has now been published for 2 consecutive weeks, January 8th and January 15th, and evidence of that is on file as Exhibit 13 in this cause. Through the mailed notice and the published notice, which, although not long enough, is actually more notice published than most people get, there have been no responses to date. No one has reached out aside from the gentleman who contacted me last night. And there are no objections on file. In addition to simply pooling the parties named here today, SM obviously seeks to have the terms of the JOA that they present imposed on this drilling unit and on the non-consenting parties. The terms of this JOA have been held by this board to be just and reasonable in multiple causes, including most recently in October 2024 in cause 13260, 13261, 13262, and 13263. Finally, before I move on with Mr. Harris' testimony, the board has jurisdiction over this cause pursuant to 40-6-6.5. And we believe that the testimony and evidence presented here today will satisfy those statutory and regulatory burdens, especially in light of the board's partial continuance to the February hearing to allow for that objection. And with that, I will begin my examination of Mr. Harris.
Thank you.
Mr. Harris, can you begin by introducing yourself?
Yeah.
State your name and business address for the record.
Hi, everyone. My name is Richard Harris. Business address is 1700 Lincoln Street, Suite 3200 in Denver, Colorado, 80203. I'm the regional land manager over the Utah assets for SM Energy.
Okay. And as regional land manager in Utah, does that do you exercise a supervisory role over the land records associated with the unit at issue?
Yes.
Okay. Can you please provide the corporate and bonding status for the board?
Yeah, SM is a Delaware corporation, which is in good standing, and our principal place of business is in Denver, Colorado, and we are fully bounded as required with the relevant state, federal, and tribal agencies.
Okay. It'd probably be appropriate at this time. I intend to have Mr. Harris, or try to have Mr. Harris recognized as a petroleum land management expert. So I'm going to try. I don't know if there's any follow-up until we have a chance for the division or board to ask any questions they would like of your resume or expertise.
Yeah, just you indicated that most of your experience was in the Rockies. How much is in Utah though?
A little bit. We McIlvain operated some vertical gas wells in Uinta County, Utah, and I worked on those from there.
And your resume indicates you're regional land manager of Utah. Is that just since SM Energy acquired these assets?
That is correct. My prior title was land manager over our Sweetie Peck prospect in Texas.
In Texas. And then could you just describe kind of what you do on a regular basis in that role?
In the Utah role?
Yeah, as a regional land manager.
Yeah, so we have a surface team, so we also manage the surface team, and then the subsurface assets, buying and selling leases, working with other companies, other operators on joint operating agreements, trying to get them to participate. We do deals where we will do buy and sell leases between companies, or do data trades, and just kind of handle the land aspect for the company over the Utah, or new Utah assets.
Yeah. And do you manage any other land staff?
I do. So right now we have 3 landmen on the Utah team, land tech, subsurface landmen, and then on the surface side we have 2 surface landmen that also report up through my org chart.
Yeah, thank you. Yeah, the division has no objections to recognizing Mr. Harris as a professional in this field.
Board, do you have questions for Mr. Harris? We will accept him as an expert witness.
Thank you. I appreciate that. I guess it's probably appropriate. We've kind of mentioned, your expertise and the acquisitions. Before we start, SM hasn't been before the board. Can you talk briefly, or to the extent you're comfortable or want to, about how SM got here, the acquisitions, what you bought?
Sure. Yeah. So SM Energy's been in business for over 100 years. They started out after buying a position in St. Mary's Parish in Louisiana. They expanded that, and so for a long time we were called St. Mary Land and Exploration. They expanded that asset and operated throughout the continental United States. And then in around 2016, the company kind of changed its focus and primarily focused in the state of Texas, all their operation efforts there. Until last year, we acquired XCL. We're really impressed with the operations and their land position that they were able to put together. And we also got some block on another acreage position that blocked onto the XCL asset from Altamont Energy. And we're really excited to continue to grow the position and work in the state of Utah, and hopefully to follow XCL as they put together great operations. And we're excited to keep, hopefully grow that position and keep pushing what we can do out there in Shane and Uinta counties.
So in addition to the board, this is for the public members who are watching this. If they've had interactions with Altamont or XCL, they should come to SM now for those.
That is exactly right.
Okay. Yes. That's helpful. Thank you. And as a result of these acquisitions, is it fair to say SM has assumed any contracts or business dealings as successor in interest to both Altamont and XCL?
That is correct.
Including the JOAs here?
Yes.
Okay.
We're a successor operator under both companies.
Perfect. Okay, thank you for that. Now, moving on to the details of this, we're going to try and get through some of these background exhibits quickly. Do you recognize what's been filed as Exhibit 4 in this cause?
Yes.
And was it prepared by you or someone on your team under your direction or supervision?
Yes.
Okay. Briefly, help orient the board. Where are we talking about?
Yeah, so we're talking about 4 sections, what we call the Rock Top Gun 2560 unit, which is comprised of sections 13, 14, 23, and 24 in Township 2 South, Range 3 West in Duchesne County. As you can see, we're about 8 miles west of the town of Roosevelt and just southeast of Upolco.
Okay. And this is a lay-down-oriented unit, is that right?
That is correct.
Okay. Exhibit 5, same questions. Do you recognize this?
Yes.
And was this prepared by someone on your team or under your direction or supervision?
Yes.
Okay. What is this and what does it show?
So those are maps breaking out the ownership by tract in the 4 sections that we're talking about today. We have updated title opinions that brought us to these ownerships. We have a section 13 and 14. We have a drilling and division order title opinion that was dated October 5th, 2023. And then sections 23 and 24, we have a drilling and division order title opinion dated effective April 3rd, 2022. It identified in those title opinions the 15 tracts that are shown on these plats.
Perfect. The title opinions you mentioned, what do they determine about ownership that's relevant to this hearing?
So we order the title opinions to find out who owns what and to confirm our ownership. And in the case of this action, we saw that there were 2 unleased owners, Lloyd Goodrich and Adrian Larson, that were not subject to a current oil and gas lease.
Okay. Do you have approximate ownerships for either of those 2?
We do. So Lloyd Goodrich has approximately 0.004651% in this unit, and Adrian Larson has an approximate 0.016228%. So pretty small interest. Collectively, it's 0.02%, roughly.
Roughly. Okay, thank you for that. And also there are 15 estates. Can you just confirm on the record that SM either hasn't seen or has seen insufficient documentary evidence to convey out of these estates, and that's why they're named here today?
That is correct. So the title opinions didn't show that these estates were fully probated, so out of abundance of caution, we wanted to notify all those people in case there's some other heirs out there that we need to talk to.
Okay. And those estates are the same as the estates. There have been no changes, so they are the estates listed on pages 2 and 3 of the request. Is that right?
That is correct.
Okay. There was one estate that I mentioned reached out to us. I believe it was the estate of Joanne G. Walker. Can you just give the board your understanding of that call and kind of where it is in the process of resolution?
Yeah, so he called Mitch last night saying why, I guess we do not know. I don't know if he found it in the actual publication notice. I think he had to because we didn't have a good address for him, which is pretty neat that these publications are actually working and people are seeing their names in the small fine print of the Uinta Standard newspaper.
Yeah.
We're going to immediately reach out to him, and if he is unleased, we will offer him a lease at the same terms that we send in the proposal letter and get him under lease. But we need to confirm first with the title opinions exactly his heirship and how he was part of the estate of Joanne Walker. We will do that and try to get a deal with him.
And is it fair to say that you still don't have sufficient proof of distribution of the estate of Joanne G. Walker?
That is correct.
This is just a more or less a protective lease offered to her widower.
It would be, for sure.
Okay. Thank you. So you can confirm that all 15 of the estates named in the request are still to be pooled here today?
Yes.
Okay. Now I'm going to quickly move you on to what's been filed as Exhibit 6 up on the screen here. Exhibit 7 and Exhibit 9. Do you recognize these 3 exhibits?
Yes.
And are these official business records of XCL, now SM?
Yes.
Can you, what are these collectively, what do you think of these as?
So these are standard kind of well proposals that were mailed to because this one in particular was to Lloyd Goodrich, and because he was unleased, we sent him an opportunity to participate in the 2 goose wells. In the letter, it talked about he has a 30-day election notice. Does he want to participate with us? And in the event he doesn't want to participate, XCL at the time and SM offered to lease his interest or purchase the minerals underneath the thing. underneath these tracks.
Okay, and it also includes language if they don't make a timely election that this board hearing may happen.
That is correct.
Okay. In addition to that, Exhibit 6, as I mentioned, you send with those letters.
Yeah, so Exhibit 6 shows, we call it the Authority for Expenditure, AFE. It shows the cost of drilling and completing the goose wells. So that came with the well proposal.
Okay. And also, can you confirm that the well location plats are also included with these election letter packets?
Yes, that is correct.
Okay. Those show the bottom hole, surface location, et cetera, the technical information someone would need to make a determination?
For sure.
Okay. Can you also confirm that the targeted member of the formation is identified on the AFEs?
It is.
Okay. In addition to that well proposal letter and the AFEs, you also send with it, you said, Exhibit 7.
Exhibit 7 is a Model Foreign Joint Operating Agreement. This form is the AAPL Form 610-1989 form. It covers all the 4 sections of the unit, and the modifications in there are typical industry standard stuff that we put in there for horizontal wells. As everyone knows, in 1989 there wasn't as many horizontal wells as there are today, so we've added some. The industry's worked hard together to kind of get a form in there and have some modifications in there. Also included in that JOA is the non-consent penalty. The one that we proposed there is 100% for surface equipment and 400% for drilling, completion, reworking costs, which is also standard for horizontal wells. Is 400% is kind of in line with. It's a lot risky and a lot more expensive to drill horizontal wells, so 400% is kind of an industry standard for the JOAs for horizontal wells.
Okay. Now, just to clarify for the board, the JOA you submit to other operators to sign, to other non-operators to sign, the JOA you sign on behalf of SM in relation to this contains a 100%, 400% risk compensation award. But here today at the hearing, what risk compensation is SM requesting?
300%.
Okay, so the 100, 300%.
Yes.
Okay, just for clarification, thank you. So the well proposal packet, there's a letter here that we're looking at that is addressed to Lloyd Goodrich, and another letter here addressed to Miss Adrienne Larson. Can you confirm that these election packets were mailed to the folks identified? Yes. And do you have approximate delivery dates for those that you could?
We do. Mr. Goodrich received his on January 26, 2024, and Adrienne Larson received hers on May 3rd, 2024.
And kind of silly housekeeping, you can confirm on the record neither of them responded within 30 days of that receipt.
That is correct.
Okay. Now I'm going to turn you, if I can, to what has been filed as Exhibit 14. These are just the proofs of service of the certified mailings. Can you tell the board, was this prepared by my office under your direction or supervision?
Yes.
And what generally does this evidence related to this cause?
So these are just the certified return receipt green cards, as we call them, or maybe I call them. But it shows that we properly mailed it on those dates, and then we get a return card that has their signatures on there that they did actually receive the mailings.
And I apologize for the small size on the print. We'll fix that for the next month's hearings. So these are essentially proof confirmation that Adrienne Larson and Lloyd Goodrich received copies of the request also.
That is correct.
Okay. We talked a little bit about published notice earlier. I know that as is typical in pooling matters, you also attempted to publish notice to the estates and anyone who may have an interest in these wells and didn't receive direct notice. The board has already dealt with kind of the notice of opportunity question in the motion for continuance, but I'd like to have you just confirm a couple things for the record. Did you attempt to publish that notice?
We did.
And was it successful initially?
Yes, it was.
It was. Okay. The first publication there was an issue with, but eventually they got it sorted out and have now published it appropriately.
Yeah, and I don't know if anybody's going to know the story, but the paper on Christmas didn't get notified correctly. So
I hope someone took a holiday and just forgot to do it.
That's exactly right.
Okay, well, that's helpful. Let me double check here. except for the call that was received last night from a presumed heir of the estate of Joanne G. Walker. Are you aware of anyone who's reached out, either named in the request or not named in the request, to raise concerns, objections, or ask about participation?
No, we haven't received any other calls as of today.
Okay. Now I'm going to simply turn you what's been filed as Exhibit 13 in this cause. The affidavit of publication, as the board can see. Excuse me. You've already confirmed all of this, but can you just confirm what this exhibit is and what it shows? Have you seen this exhibit?
Yes.
Okay. And was this prepared, again, by my office under your direction or supervision?
Yes.
Okay. What is this? Does this confirm essentially the testimony you just gave?
It does. This is basically it's an affidavit that the paper ran the publication, the notice on January 8th, 2025 and January 15th, 2025.
Okay, perfect. I'd also like to note for the record, there is a notice regarding publication error on file in this cause that kind of explains the backstory. Now there's a giant exhibit that we have to talk about.
Mm-hmm.
The board has seen something like this before on several occasions. Do you recognize this exhibit?
Yes.
And was this prepared by you or SM personnel under your direction or supervision?
Yes.
Please tell the board what this is.
So this is a spreadsheet that we put together to calculate the average weighted landowner royalty. As you can see on this exhibit, it's quite long. There's over 1,100 leases in this unit. It shows the lease number, the lease net acres, the royalty rate in each lease, and then we did a tract participation factor, which just divides the net acres in each lease over the total unit. On this particular unit, we have 600 acres of tribal acreage that we had to take out of the total acreage to get the fee royalty interest, just based on state statute. Mm-hmm. And our total weighted royalty, after you calculate all those 1,100 acres out, and then you take out the tribal acreage and keep it to just the fee acreage only, is 13.12%, approximately.
13.2%.
13, yeah, sure.
Is it correction?
13.12. I mean,
that's
yes.
199.
199.
Yeah, that's okay. So, to reiterate, did you say there's 1,108 leases in this unit?
Yes.
And only 2 parties who didn't lease?
That is correct.
Okay. And again, to reiterate let me read it to you because it's probably hard to see. Can you confirm that the acreage weighted royalty that SM seeks to apply in this cause is 13.199579%?
That's the exact average weighted royalty percentage.
Okay, perfect. Finally, you've gone through the JOA, but I'd like to hit on just a couple provisions really quickly. As you testified, you use a model form 1989 JOA that's been modified slightly to address horizontal operations. And one of the examples of the modifications you gave was the 100-400%
Yes.
that I'm showing up here on the screen. Let me make sure we went out of order. In addition to the 100%, 400% in the risk compensation award in the JOA, you clarified that you're only seeking a 100%, 300% application from the board here. But I'd like to discuss the COPUS just a little bit, a couple of the provisions. I think you mentioned them, but just to hit them here.
Sure.
Do you recognize the COPUS, and can you explain kind of what it is to the board?
Yeah, so this is the standard Exhibit C COPUS accounting procedure form that is attached to all, mostly all, I probably shouldn't say all, but all industry standard joint operating agreements.
Okay.
Yeah, standard.
Well, there's a couple provisions in particular in this COPUS this industry standard accounting form that I'd like to show just for the board's knowledge and have you kind of walk through. Sure. There's one up on the page here. It's called Advances and Payments by the Parties, and I'm going to see if I can zoom in somehow, make this a little more legible. Can you high level tell the board what this is and why we're talking about it this hearing?
Yeah, so this is kind of gives you the interest rate for late payments or non-payment of well costs, and it's calculated as the Wall Street Journal rate plus 3%, the prime rate published by the Wall Street Journal plus 3% per year.
Okay. And that's the interest rate that you'd like the board to apply in this case?
That is correct.
Okay. See if I can. Last thing, in the section of the COPUS titled Overhead, can you please talk about this provision and why it's here as well?
Yes. Yeah, so these are the overhead rates that the operator charges to the non-operators for their services as operator. It contains a drilling well rate at $10,000 per month, and then a producing well rate for $1,000 a month.
Okay. And in your expert opinion, to kind of sum up all this, do you believe the terms, conditions in the JOA presented before the board and asked to be imposed here are fair, reasonable, and justified in this cause?
Yes.
Okay. With that, I have no further questions for Mr. Harris, pending any questions from the division or board.
Division.
The division has no questions. That was a thorough testimony and answered all of our questions already. Thank you.
Good. Thank you.
Board, do you have any questions for this witness? Mr. Church.
So in this proposed pooling, there are already existing 2 wells, the 2 Goose wells. Is that correct?
Yes, sir. Those wells are currently producing.
And those are drilled to one section, or are they 2 miles?
They're 2-mile laterals, lay-down laterals.
They're lay-down laterals. Okay, I just didn't see an exhibit of where they were at, so
we didn't include that, and typically we don't in the XCL poolings that we've done. We haven't really submitted an exhibit that shows them. You've been used to seeing OVINTIV poolings for a long time, and they do. I'm happy to start including that, but we don't have one for this because they're section line wells. Essentially, they're basically centered on that center line between the 4 sections, and so I can delineate, but we don't have a map. I'm happy to supplement the record if you'd like to see those.
okay. Well, just to remind me on the original spacing on this, is there a limitation on the horizontal wells that can be drilled?
Yeah.
So there are 2 drilled now, and in the 4 sections there can be how many more wells drilled?
In this drilling unit as currently established, so 2-mile lateral horizontals that produce from sections 13, 14, 23, and 24, there's only 1 more location available. The 604 order, at the time that section line wells were kind of starting to be established by the board, the density that was most commonly requested was 3 wells. It was thought that they were essentially a catch-all. They'd come in and drill those as they did them. SM, prior to their acquisition, XCL was in here this summer and requested new 3-mile units and overlapping 3-mile section line wells, 1920s and 3840s. Essentially those, they said, we'd like 5 section line wells because we believe the density should increase a little bit. So the short answer is 3 wells are allowed. There's 1 left available in this unit. But based on XCL's testimony, there's likely the ability and the need to increase density on these section line units going forward.
Okay, thank you.
Yep.
Mr. Mayo, I think going forward, I would like to see an exhibit that shows location of existing wells and the proposed wells, the location of the proposed wells, just for clarity. Thanks. Thank you. Mr. Moon.
Yeah, my comments are similar. First one, to welcome to Utah. We're excited to have you here. I have a lot of friends that have interest in your wells, and XCL did a good job, and Axia before them did a great job proving up a field that has really made the basin what it is, and so you're continuing that on, and we're excited for you to be successful as mineral owners.
I appreciate that. We're very excited too.
So first, I want to start with a compliment on the way that XCL and now you have done force poolings. I do really like your notice of opportunity to participate letter. It's very clear. I think it's not required, but it's neat to have an offer to purchase. That kind of sets a benchmark because you're probably aware mineral owners receive hundreds of offers to purchase, and they're not always from very upfront. Well, there's good buyers out there, and there's buyers that try to just get mineral owners that don't know what they own to sell. So it's nice to see offers out there to establish values, and so anyway, I like that, and I like how clear it is. You can participate, you can be force pooled, or we'll lease you, and there's an offer right there. So I really appreciate that. Just with the land exhibits, though, I do really like where OVINTIV does the tract ownership. Fee, tribal, allotted. That's just helpful to see. I'm sure it's not required because it hasn't been done in the past by XCL, but that's helpful, along with existing wells and just a little clearer topography. We know Roosevelt's here and this is there, but just a little bit. Yeah.
Harris and I had a joke about that exhibit last night. It's one of those where, as an attorney, I do my clients' bidding, and some clients do great work, some clients do good work, some clients do awful work. XCL did great work, but their business was oil and gas. It wasn't exhibit preparation. So, I have SM's assurance those will be improved.
Okay. And just a small note, it's not a requirement yet. I know we've started some rulemaking on these notices of opportunity to participate, but they are quite Greek to most mineral owners. Just a net mineral acre, just letting the person know what we believe you own would be helpful. I know it's not a requirement yet, but most don't know to take that and multiply that or ownership by the acres in the drilling unit. And I'm not sure if yours showed the acres in the drilling unit. It might have. But just so that there's a little bit of a feel, hey, this is what we believe you own, and here's your options with it. That may be helpful. It's still going to be hard for most mineral owners to understand that, but that would be helpful.
Yeah, that's a great idea. We'll make sure that's in the letter. And those are great comments. And it's always in SM's best interest to lease unleased owners or purchase their minerals. So we'd much rather do deals with them than you all seem like nice people, but we'd much rather get them under contract rather than having to come to these hearings.
So just a question more for Mitch, because all the companies seem to do this. The lease option is usually last, kind of in just a little bit. Why not put that up front? Because I know that it's better in your best interest to lease. Why are we talking about participating and threatening, if you're going to get force pulled, and then finally, if you want to lease? Is that the way the statute is ordered? Is that why it's?
I think, to be honest, to speak plainly, the NOP revisions have kind of happened via board process. There hasn't been that formal revision since the last. And I think the regulation has stated, says an offer to lease. And so typically the NOP said, if you'd like to lease to us, let us know. Also, if you'd like to participate, do that. And as the boards kind of wanted it to be fleshed out more, I think operators have just put them in a way that makes sense. Mm-hmm. But genuinely, I think there's kind of a fear, and this is purely anecdotal in my perspective, but I think there's a little bit of a fear that if you don't make it clear to mineral owners in Utah they have the right to participate, they may come in and complain that they didn't get that right and the lease was shoved down their throat. Yeah. And so I think a lot of operators are just trying to say, listen, we know this is Greek to you. We know that most of what we send you is just confusing. We'd like you to know there are 4 options. You don't have to take our lease. You don't have to. Every letter they get from a company, it seems, and I'm aware of what you're saying, is sell to us. Lease to us. It's all, and it's really hard to see that as anything but pushing an agenda when I look at them, because they are, right? It's a business trying to get business. And so I think the operators, at least the operators I've worked with, have tried really hard to make these, we're going to let you know your options. If you have questions, you do what you will with them. But if the board would like to see them restructured or anything, I think a formalization of those NOP adjustments would be great.
No, you've actually convinced me. I like that opportunity to participate. A lot of mineral owners don't know that they even have that. I mentioned that to people, and they're like, "What? I can participate in a well?" I'm like, "Yeah, I just don't lease." But it's in most mineral owners' best interest to lease, and it's in the operator's best interest to hold those leases. And so, but that makes sense what you said. I'm not asking you to reorder that at all. It's just a.
We're always looking for a new way to make a better mousetrap. So if there's something we can improve, just let us know.
Good. Thank you.
With that, I'm done with Mr. Harris unless there are further board questions.
Any further questions? Okay, let's move on.
Okay, Mr. Peterson. And stay close by because they may have random follow-ups for you. Thank you for that. Mr. Peterson, while I get the exhibit up, why don't you introduce yourself? State your name and business address for the record.
Yes, it's Brad Peterson. Oh, sorry. Brad Peterson, and I work in the SM office on 1700 Lincoln Street, Suite 3200, Denver, Colorado, 80203.
Okay. And please, it's up on the screen, but will you tell the board your job title currently with SM now with their new asset and your role as it relates to this request?
Yeah, it's Utah Asset Manager. I'm in charge of a team of about 20 technical staff, geologists, and engineers, and we work to optimize the development plans for our acreage position.
Okay. So it wouldn't be fair to say you're kind of in charge of how the Utah asset's going to be developed?
Yes.
Okay. Mr. Peterson, you have yet to testify before this board, so I'm going to attempt to qualify you. Obviously, we've seen your resume and can look at it here. Without having you kind of go through it, can you talk about the highlights and help explain to the board why you believe you're an expert in petroleum engineering?
Yeah, so I have a degree in petroleum engineering with a minor in chemistry from Montana Tech University. I have 23 years of experience. I worked for ConocoPhillips for about 11 years, Talisman, and then my last 11 years has been here at SM Energy. I've worked in our South Texas and Eagle Ford asset as well as our Permian asset, responsible for and involved with drilling and executing over hundreds of horizontal wells. My last role prior to becoming the Utah asset manager was the Permian region asset manager. So I had a similar team that kind of worked in to optimize the development plans. Lastly, I am a registered professional engineer in Texas. So I've got that as well.
Okay. I appreciate that. Without me guessing what questions are important to the board and division, it's probably appropriate to turn time over to the division or board to ask any voir dire.
Yeah, the division has no questions on his resume and is happy to accept him as a professional in his field, expert in his field.
Board, do you have questions for this witness? We will accept him as an expert.
Thank you, Madam Chair. Having qualified him as an expert, there's really only a couple exhibits for him to look at, and those are essentially the costs, the AFE costs, and the actual costs, and kind of how those flesh out. Mr. Peterson, I'm going to turn you to what has already been authenticated by Mr. Harris, but what's on file as Exhibit 6 in this cause. You tell the board these are the AFEs, what they show relative to your testimony.
Yeah, so we provided these AFEs. They're the estimates for costs for the well. Both, we show drilling, completion, kind of equip cost, and then total well cost. Summed up, and that is sent out to everyone to look at.
Okay. And what are the estimated costs for the two wells? You can give rough ideas or exact numbers, whatever's easiest.
Yeah, the two wells are right at 8.1 and 8.2 million dollars, roughly.
Okay. And that's drilling completion.
Yes.
Okay. Now, Mr. Harris testified that the two parties to be pooled collectively own about 0.02%. What is their share of well costs for these estimated wells?
Yeah, for the two wells in total, that 0.02% equates to about $3,500.
Okay, so not much money,
Right.
but SM has paid that $3,500 on their behalf.
Correct.
Okay. Now, you didn't prepare, SM didn't own the asset when these AFEs were prepared. It's your understanding, though, is it true that XCL doesn't include P&A costs on AFEs?
That's correct.
Okay. Can you estimate what you believe P&A costs? I think XCL's used $100,000 in the past, maybe, and OVINTIV's used $75,000. Does SM have an idea of what they believe?
Yeah, I think it'll be somewhere in that range of 75,000 to 100,000. There's a lot of different factors that go into P&A and wells properly that make that a range of well costs.
Okay. Now I'm going to turn you to the last exhibit, if I can find the number. Exhibit 10. We talked about the AFE costs. Can you tell the board what this exhibit is? Well, first of all, do you recognize this exhibit?
Yes.
And was it prepared by you or someone on your team under your direction or supervision?
Yes.
Okay. What does this show? We've already talked about the AFE cost, but what does this show and what do you need to say about this?
Yeah, so this is the cost for the two goose wells. What it shows is the AFE cost. Directly shown next to it is the actual cost that it cost. The one thing that I will point out is on the Goose 70 well, we had significant issues on that. So they were so you can see that we overspent it by over $3 million. So on that well, we had hole stability issues in the black shale. We lost a BHA in the hole. We tried to fish it out, and then we had to sidetrack.
And if I can jump in, for anyone who doesn't know, a BHA would be a
bottom hole assembly for the drilling. And then we had to sidetrack the well and re-drill it. So we were able to successfully re-drill the well, but it did cost a significant more amount than planned.
Okay. So despite the best estimates, same rig, same location, same execution, same plan, there was a significant cost overrun in one of the wells and not the other.
That's correct.
Okay. And on a unit basis, these two wells that Mr. Church asked about, these are the numbers. There's a second page to Exhibit 10. Can you talk about this just kind of briefly? It leads us into the next cause anyway.
Yeah, so this is, again, the same showing the same thing for all the wells here. So you can see the AFE amount versus the actual amount, and then the difference shown for each of the wells. What you can see is really that Goose 70 well is the large outlier, had major issues. Other than that, they were very, very close to AFE amounts. What you can also see there is the total amount for all those wells ended up being about $80 million, so significant investment that SM and XCL had to make well in front of, I guess, getting these wells drilled and online. But it also shows that there is some complexity on execution of these wells with that Goose well. Even though they're drilled by similar rigs, similar group on pads in close proximity, there's just the geological complexities as well as the operational and mechanical complexities make it so there is some uncertainty on executing on the AFE cost estimate.
So none of the wells hit the estimate, obviously.
Right.
A handful were above estimated costs, a handful were below estimated costs, but one outlier kind of throws the economics in a different direction.
Correct.
Okay. Anything else you want to add about risk or about the costs in this that I didn't hit on?
I think really at a high level, I know you guys hear a lot of these hearings, but starting at the drilling execution front, you know, even setting conductors, we've had some challenges out there in the Uinta asset, as well as, you know, drilling surface intermediates, as well as, you know, the long lateral, different natural fracturing, faulting that we drill across, as well as hole stability. It is high pressure, so there is uncertainty and added risk in execution for horizontal wells, and then really that potential for issues also extends through completions and production phases. We've had in some cases casing collapse or kind of, you know, issues on the completion side as well as after production, hole, plugging off and require additional remediation work. So really, bottom line, we do everything we technically can do to try to execute these as efficiently as possible, but there is inherent risk on execution for all these projects.
I appreciate that. I have, I guess, the last question. In your expert opinion, Mr. Peterson, do the risks inherent in these wells and actually encountered in the drilling of the Goose 50 and Goose 70 wells, in your opinion, justify the 300% risk compensation award requested?
Yes.
Okay. I have no further questions for Mr. Peterson.
Division, do you have questions?
Just one question. I noticed that the Goose wells, it indicated that they spud in October of 2023, but first production wasn't until October of 2024. Is that 1 year typical of this region, or is there a reason for that delay?
I think that's probably a good average that we see. So, for us, the planning cycle with the permitting, it takes, we plan 3 to 6 months in front of the permitting, and then we drill the wells. Depending on the size of the pad, the larger the pad, the slower the cycle time. So on the larger pads, and then kind of we try to, we work pretty hard to kind of have these long areas that we drill them kind of sequentially, and then frack right after and put them online. So kind of coupling that up with the completions but just really, we're taking right now, it's about 17 days per well. Mm-hmm. To drill, so you multiply by the pad sizes, and then have a gap so we don't have sim operations next to our drilling rig from our completions crew. All that coupled together, that is probably a good kind of time frame for cycle time.
So all 10 of these were drilled sequentially?
Yeah, they were drilled on the same together on the pads. Yes.
Okay. All right. Thank you. Yeah. No further questions by the division.
Board, do you have questions? No further questions, Mr. Mayo?
Thank you, Madam Chair. With that, I believe it would be appropriate, let me make sure I've confirmed, to move for admission of my exhibits at this time, because I'm done presenting our case in chief.
Okay.
So I'd like to move for what's been filed as exhibits 1 through 10 and exhibits 13 and 14. And then I'd reserve any final remarks if necessary.
So accepted.
Thank you. Madam Chair, if you'd like me to close, or the division, I don't know if they
Division, do you have any further questions for this witness?
We have no questions, but we're happy to state that we reviewed the petitioner's RAA and their exhibits, and we listened to the testimony here today, and the division is satisfied that they have met the regulatory and statutory requirements for their request, and we have no opposition to it.
Thank you. Board, do you have questions or comments? Are we ready to make a motion? Oh, I'm sorry.
I'm closed.
I'm excluded. You're closed.
Thank you for that. But,
yeah.
Just note in whoever makes the motion that it'll be a partial grant. It'll be a grant and the order to finalize. That'll be
in February.
That's right.
Okay. Do we have a motion?
So I would move that we approve this request for agency action for final approval next month.
Do I have a second?
Second.
It's been moved and seconded. All in favor, please say aye.
Aye.
Any opposed? Motion carries. And I guess we'll wait until next month for your order, Mr. Mayo.
That's right. I'll get a draft ready to go this week, but until that February hearing, we won't know. Until February 15th passes and we know there are no objections that are valid, I won't have a draft. But sometime that week, I'll get it out to council.
Thank you.
Thank you. Madam Chair, we've got one other matter. Luckily for us, it's the same witnesses and it's the same parties being pooled and it's similar land. So we can go quickly or we can wait till after lunch, board's preference.
I was just going to say, I'm going to make an executive decision to take a 10-minute break here. Do we want to? Yeah. We'll be back in at 11:25.
Perfect. I still think we can finish by noon.
Okay. Thank you.
5.
Thank you. Back after our break and moving on to the next docket item. This is docket number 8, docket number 2025-005, cause number 132-69, in the matter of the request for agency action of SM Energy for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 1,280-acre or substantial equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch Colton formations, sections 13 and 14, 2 south, 3 west, USM, Duchesne County. Mr. Mayo.
Thank you, Madam Chair. Mitch Mayo of Lear & Lear, PLLC, on behalf of the petitioner, SM Energy Company.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining, and I'm also joined by Colton Goodridge, who is a geologist with the division, and Regina Echo, who is a petroleum engineer.
Thank you. Mr. Mayo, we assume that since your witnesses just testified, we can forego the swearing in of them for this matter.
I leave that entirely to the board's discretion.
Thank you.
Yep.
Please proceed.
If you'll notice on the screen, for some reason, my PowerPoint exhibits are currently not responding. So I'm going to proceed for the first few minutes. If we have a technical issue, we'll take a break, but I think we can probably navigate it.
Thank you.
Madam Chair, as you said, Mitch Mayo of Lear & Lear, appearing on behalf of the petitioner, SM Energy Company. Same witnesses, same company that you had in the prior cause. With me today from SM are Mr. Rick Harris, the Regional Land Manager for Utah for SM Energy, and Mr. Brad Peterson, the Utah Region Asset Manager for SM Energy. Both have been recognized and qualified as experts in prior causes before this board a few moments ago. And so it'd probably be appropriate to swear them in and also maybe have recognition that they are approved as experts in their respective fields for this cause.
Okay, you'd like to have them sworn in?
Please.
Mr. Walker.
Oh.
We weren't going to do it, but...
I missed the cue even, the social cue. I apologize.
Let's just go ahead.
Do you solemnly swear that the testimony...
Can you turn your mic on, Mr. Walker?
Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Yes.
Thank you.
Also, please note that these two witnesses have prior been accepted as expert witnesses. Mr. Mayo, would you please proceed?
Yes, thank you, Madam Chair, and I apologize again for confusing the process here.
No problem.
As noted, and as in prior causes, the resumes of Mr. Harris and Mr. Peterson have both been submitted as part of Petitioner's Exhibit 1 in this cause. If asked, they would separately confirm the contents of their resumes as true and correct. I believe I've gotten the PDF up and running again, so let me try this. Okay. Also consistent with past practices, I'll just be moving for admission of exhibits at the close of our case in chief.
Thank you.
Like the cause before this one's very straightforward. The cause before you heard was a 4-section unit comprised of 13, 14, 23, and 24 in Township 2 South, Range 3 West. This is one of the 1280 units that make that up. The matter before you now is the pooling of sections 13 and 14, otherwise known or sometimes known as the rock unit. This drilling unit, sections 13 and 14, 2 South, 3 West, was established by the board for production from Lower Green River Wasatch formations, the subject formations as more particularly defined in the request for agency action. This unit was established by Order 139-153 and is subsequently modified by Orders 130-06 and 130-21. Those will collectively be referred to as the current orders. Together, the current orders authorize up to 32 long lateral horizontal wells to be drilled on and produced from this 2-sectional drilling unit, so long as they maintain 560-foot lateral boundary setbacks and 100-foot heel-toe boundary setbacks. Pursuant to the current orders, XCL has drilled and SM now operates the following long lateral horizontal wells producing from this unit and requested to be pooled here today. The Rocket 53-1413-23F well, the Rocket 56-1413-23I, the Rocket 61-1413-23D, the Rocket 65-1413-23H, the Rocket 68-1413-23K, Rocket 71-1413-23E, Rocket 75-1413-23G, and finally the Rocket 77-1413-23J. These 8 wells, as mentioned, all produced from the subject unit. As in the prior cause, the request before you includes the compulsory pooling of only 2 parties, Adrian Larson and Mr. Lloyd Goodrich. And if I could take 1 minute just to confer with the client off the record. I apologize for that. So 2 parties here to pool, Lloyd Goodrich and Adrian Larson, the same 2 parties. As you'll hear, a copy of both the election packets and the request were sent to each of these parties and returned with no response to date. In addition to these 2 unleased mineral owners, this request also seeks to pool, to the extent necessary, the 8 estates that are identified on page 2 of the request for, or page 3, excuse me, of the request for agency action. Again, SM believes that all successors under these estates have been located and leased, but out of an abundance of caution, because there aren't court orders, essentially including those estates to be pooled. As in the prior cause, there was an unexpected, unanticipated problem with notice through no fault of SM's. That has been remedied by republishing that notice. Essentially, December 18th and 25th, it was supposed to be published. For some reason, December 25th, the notice was not published. Uinta Basin Standard has clarified that and has since republished the notice January 8th and 15th, and an affidavit evidencing that publication is in the record in this cause. As in the prior cause, we believe that it's appropriate to present the information here today and have the board make a determination as to the appropriateness on the request. However, we also believe it's appropriate to hold the formalization of the order to the February hearing. And so on that basis and pursuant to the rules, I'd make an oral motion to continue this hearing partially, have the evidence heard and considered today and a vote made, and then have the matter formalized at the February hearing in consideration of any any objections, if any, that come in.
Division, do you have any comments?
Yeah, we have no objection to that proposal. In fact, we're in favor of that.
Board, do you have questions, or do I have a motion?
I'll make a motion that we continue to February as requested.
Do I hear a second? It's been moved and seconded. All in favor?
Aye.
Aye.
Any opposed? Hearing none, we will continue the final order until next month.
Thank you, Madam Chair. In addition to pooling the 2 named parties and the 8 estates, SM seeks to have the JOA that they've submitted as an exhibit imposed on the parties in this unit to help control costs and plan for the payment of those costs going forward. Finally, I'd like to remind the board that the board has jurisdiction over this cause pursuant to 40-6-6.5. And although in the division's response on file, they correctly noted that at the time they filed it, the regulatory and statutory requirements had not been met, we firmly believe that the evidence presented here today will meet those statutory and regulatory requirements, especially in light of the partial continuance to allow for additional objections. And with that, I'll begin with my my testimony, or my examination, excuse me, of Mr. Harris.
Thank you.
Mr. Harris, you were just here talking, but could you please state your name and business address for the record again?
Yeah, my name is Richard Harris. I'm the regional land manager over Utah for SM Energy. Place of business is 1700 Lincoln Street, Suite 3200 in Denver.
Okay. And can you please provide SM's corporate and bonding status?
Yeah, SM is a Delaware corporation in good standing with our principal place of business in Denver, Colorado. We are fully bonded with all relevant state, federal, and tribal agencies as required.
Okay, and in the introduction, I labeled you as the regional land manager for Utah. Is that is that your job title currently?
Yes.
And in that role, do you exercise a supervisory capacity over the records generally, the land records generally, and specific to this unit as well?
Yes.
Okay. One last thing, we've talked about SM's new to the basin, having just acquired the interests of both XCL Resources and Altamont Energy. Can you just confirm on the record here that you have succeeded to all contracts of those parties relevant to those acquisitions to the extent necessary for this hearing, like the JOAs at issue?
Yes.
Okay. With that, I'm going to turn you. I'm going to remind the board that Mr. Harris is testifying today as an expert in petroleum land management. But Mr. Harris, I'm going to zip you through some of these early exhibits. Help orient the board. They know about where we are, but give them a quick understanding, if you would.
Yeah, so we're in this case, we're talking about our Rock 1,280 acre unit, which is comprised of sections 13 and 14 in Township 2 South, Range 3 West in Duchesne County. As you can see on the larger map that we're going to update for next time, we're about 8 miles west of the city of Roosevelt and just southeast of the town of Upalco.
Okay. And can you confirm this was prepared by you or someone in your office?
Yes.
Okay. Exhibit 6. They saw a different version of this for the prior cause. Tell them what this is and where you got it from.
Yeah, so these are the same tracks that we got from our ownership, from our drilling and division order title opinions, except there's just 2 plats here because we're just talking about 2 sections. One is section 13 showing the different ownership, and the other one is section 14. Okay. A total of 9 tracks over the 2 sections.
Okay. And how was this ownership determined and these tract plats prepared?
We ordered a drilling and division order title opinion that we received. It was dated October 5th, 2023. And by reviewing those opinions, it set out the ownership in each of these individual 9 tracks.
Okay. Relative to the parties we've talked about to be pooled here today, what do these title opinions disclose about unleased parties?
The title opinion shows all the parties who are leased and unleased, and in that review we found 2 parties that were unleased, Lloyd Goodrich and Adrian Larson. Mr. Goodrich's approximate interest, according to the opinion, in this unit is 0.009301%, and Adrian Larson's is approximately 0.032456%. So totaling that up, it's 0.04% that we had unleased.
Okay. The request also asks for the pooling of estates. Did the title opinion identify estates that were record owners but didn't have sufficient distribution of their interests?
It did. After reviewing the title opinion, there were 8 estates that were identified that didn't have the full probate completed.
Okay. And one of those estates, just to confirm, is the estate of Joanne G. Walker.
That is correct.
Okay. We'll get back to her and probably talk about that in shortly. Turning to exhibits. Let's see. I think I can go there. Exhibits 7, 8, and 10. The AFE, the JOA, and these letters. Can you tell the board collectively what exhibits 7, 8, and 10 demonstrate, or what you think of them as?
Yeah, so those are our election letters that we sent out to all unleased parties, asking if they want to participate in the rocket wells in our rock unit. It gives them the option to participate, to lease, or to sell their interest, and tells them that if we do not hear from them with a 30-day time frame, we were going to institute the proceedings that we're talking about here today.
Perfect. And of course, I put the cart before the horse again. I forgot to ask you, are these 3 documents, the AFE, JOA, and letter, are these documents that are prepared in the ordinary course of business by XEL, now SM?
Yes.
Okay. So you said the letters, essentially, these are the election letters that you send out to unleased, unparticipating parties to give them their options to elect.
Yes.
With those, you send Exhibit 7 and Exhibit 8, the AFE and the JOA.
Yep. The Exhibit 7's the AFE. It sets out the costs of each of those individual wells that we propose, the drilling and completion costs. And the Exhibit 8's the JOA, that in the event they want to participate, they'll sign that document that governs their rights and a participation, how we operate those wells.
Okay. And in addition to the AFE, the JOA, and the election letters, do you also send the well plats?
We do. We also send a plat showing the well, the lateral links, where they're located, surface and bottom hole locations, just so they can orient themselves and know what we're doing and make an informed decision on whether or not they'd like to participate.
Okay. Now, this well proposal packet, you said, is sent out to all owners. Can you confirm that this was sent and received, I guess more appropriately, by Lloyd Goodrich and Adrian Larson, the parties requested to be pooled here?
Yes.
Okay. And can you tell the board approximate dates on when they received their election packets?
Yeah. Lloyd Goodrich received his on January 26, 2024, and Adrian Larson received hers on May 3rd, 2024.
Okay. And can you confirm on the record that you have not, or XCL did not, prior to your acquisition, receive any sort of request from the parties to participate based on them receiving these elections?
Yes, that's correct. We had not heard from him.
Okay. Turning to Exhibit 15. We call them proofs of service or returns of service. Can you tell the board what this is? Well, first of all, do you recognize this exhibit?
Yes.
And was it prepared by me or my office under your direction or supervision?
Yes.
Okay. Tell the board what this is and what it demonstrates important to this hearing.
These just show that the packets were mailed on the dates shown on the letter, and then proof of receipt that they got delivered to where they were supposed to be.
Okay. So you mailed the election packet to Adrian and to Lloyd, Miss Larson and Mr. Goodrich.
Yes.
And you also now have confirmed proof of mailing the request here at issue to both parties.
That is correct.
Okay. And you haven't received any, can you confirm whether you've received any response from either of these parties to the filing of the request?
We have not received any response.
Okay. In addition to mailed notice to the parties, there's also publish notice, an ex parte motion to publish notice to those who you don't have addresses for or those claiming under the estates. Are you aware of what's been filed as the notice regarding publication error in this cause?
I have, yes.
And generally speaking, you're aware of the notice failure that occurred and the way it was corrected in this cause?
That is correct, yes.
Okay. Do you believe that the publication, that the continuance that was granted and the additional time to object cures any prejudice, if any, to these parties to object?
That is correct. They'll have the full 30 days to elect, and it was published on January 8th and January 15th, and the 30-day clock starts then.
Okay. And SM generally, what's their approach to mineral owners who come out of the woodwork and say, hey, I have a question, I want to resolve it with you? Can you?
That's our position going forward, that if someone calls and they miss that 30-day time frame by one day, we're gonna make it right and make sure that, work something out with them and do what, either take a lease, buy their minerals, or give them the option to participate.
So SM's business is not non-consenting 0.003% interest owners.
Yeah, that's not why we purchased XCL and Altamont.
I appreciate that. Turning to Exhibit 14. Oh gosh, I was wrong. Do you recognize this exhibit?
I do.
And was this prepared by my office under your direction or supervision?
Yes.
Can you tell the board what this is and what it shows?
Yeah, this is the affidavit of publication showing that we published in the Uinta Basin Standard on January 8, 2025 and January 15, 2025, the notice of this action.
Okay. Thank you for that. Now let's go through the acreage weighted royalty if I can. Let me show you this exhibit. You recognize this exhibit as well?
I do.
And was this prepared by your office or yourself?
Yes.
Okay. Tell the board what this is and what you're asking for the board to impose here.
This is how we calculated the estimated combined average weighted royalty interest in this rock unit. It shows a total of, can you go to the?
Yeah, sorry, let's see.
A total of 604 oil and gas leases. It shows their net acres, the royalty in each of those 604 leases. We did a tract participation factor. There is also 600 acres of tribal acreage in this unit as well, so we had to take that out, which totaled it to 679.4506 net acres, and got an average royalty rate of 0.12993079%.
Okay, so 12.993079. That's the acreage rated royalty you'd ask the board to impose on the non-consenting parties.
That is correct. Yes.
Okay, and obviously the board sees acreage rated royalties that range from the high 18% to the 12%. This one's lower, but just looking at this last page, I can see a lot of 12.5% lease royalties. Is that the reason there's just legacy leases with low royalty rates?
That is correct. So it's just a straighted average, and we take all the leases and divide it by the net acres, and that's the number we came with. So yeah, it looks like, especially on that page, lease number 581 to 604 looks, well, there's a couple 20% ones in there too, but the majority of those were 12.5%.
Okay. Thank you for that. A couple, just for the record, I'm going to hit a couple points in the JOA. You've already talked, about the JOA. This is something that you send out with the election packets as part of the election process. But I want to talk specific terms for the JOA that you're asking the board to impose. First of all, what form JOA do you use?
This is a model form APL, American Association of Petroleum Landman Form 610-1989. It also includes some horizontal language, horizontal provisions for horizontal wells, just because in 1989 there weren't that many horizontal wells. Also included in there is a 100% and 400% non-consent penalty, which we feel is standard for horizontal wells in the industry right now. But today we're only asking for the 300% non-consent penalty rather than the 104.
Okay. So in the JOAs you enter into, you agree to a 400% risk compensation, but for the pooled parties, you're only requesting a 300%.
That is correct.
Okay. In addition to that modification, these JOAs are essentially lightly modified to address the fact that horizontal drilling occurs.
Yes.
Okay. Has SM, and I guess this is maybe a repeat, but has SM entered into contracts, JOAs like this, or would SM sign a JOA with terms like this?
Oh, for sure, we would.
Now I'm going to turn you to Exhibit C to the COPUS, or to the JOA. Can you tell the board what this is and what it's used for?
That's the Exhibit C COPUS, which is the accounting procedure that we attach to all of our JOAs.
Okay. Fairly industry standard?
Very industry standard form.
Okay. And just a couple provisions in there I want to point out for the board. One is in this paragraph 3 titled Advances and Payments by the Parties. Again, I'm going to try and zoom if I can to the extent people want to see what's on here. But can you tell the board what it is you want them to know about this for this pooling order?
Yeah, this provision here is talks about the interest that we can charge for late payments or non-payments under the JOA. It is established the prime rate published by the Wall Street Journal plus a 3% per year kicker on top of that.
Okay. So any well cost that you pay on behalf of someone else, they owe you interest at prime plus 3%.
If they don't pay.
Okay. One last There we go. Last thing I'd like to address in the JOA and the COPUS is just that overhead allowable. Can you talk to the board about that?
Yeah, so this is the rate that operators can charge their non-operators for operating for the benefit of all the parties. It shows a drilling well rate per month of $10,000 and a producing well rate per month of $1,000.
Okay. So when the board imposes the JOA, these are some of the provisions in particular that they'll be imposing relevant to these non-consenting parties.
That is correct.
Interests. Okay. In your last question for you, in your expert opinion, are the terms and conditions of this JOA just, reasonable, and customary in the basin?
They're definitely customary and reasonable, and yeah, I agree 100% with that comment.
Okay. With that, I have no further questions for Mr. Harris, pending division or board questioning.
Division, do you have questions?
The division has no questions for this witness. Thank you.
Board, do you have questions? Mr. Walker?
Yeah, thank you, Mr. Harris. On both of these forms, on both of your 610s, you had 400%. What jurisdictions are you achieving 400% penalty in? We have not yet approved anything exceeding 300% that I'm aware of.
So where are we coming with the 400%?
Yeah. What jurisdictions are you getting that?
So I think it's not even a jurisdiction thing. I think the jump from 300 to 400% industry wide is based on the horizontal drilling. It's just it gets more risky to go 2 miles down and 2 miles sideways. And so I think just industry standard wise in all the basins, you see a 400% from operators on a non-consent penalty in a JOA. So we definitely used them in Texas before. All the XCL prior to us here, they've been using 400%, and I've seen JOAs in Colorado and past practices too. And once the horizontal started kicking off, though, you wouldn't see 300% as often as you did it back in the vertical conventional days.
Okay, thank you.
Do we have any other questions? Mr. Mayo, back to you.
Well, thank you. Mr. Harris, you're welcome to sit down. We may have follow-up questions for you, so stay close. My last witness is Mr. Peterson again to talk about a couple of the cost exhibits. Mr. Peterson, while I attempt to get the exhibit up on the screen, can you state your name and business address for the record again?
Yeah, sure. Brad Peterson. I work out of SM Energy's office in Denver, 1700 Lincoln Street, Suite 3200, 80203.
Okay. And what is your job title generally, and how your responsibilities cover this drilling unit?
Yeah, so I'm the Utah asset manager. I am over all the development, optimization, and planning for the Utah business unit. I've got a team of roughly 20 geologists and engineers that'll be working to kind of optimize development plans for this area.
Okay, including this unit, I'm assuming.
Yes.
Okay. I'd like to remind everyone before Mr. Peterson addresses the exhibits that he will be testifying as an expert witness in petroleum engineering here for this cause. Turning you to the two exhibits that I'd like you to discuss, Mr. Peterson. Exhibit 7. Wait. Exhibit 7. Can you kind of talk through generally? There's 8 wells, so you don't need to get terribly specific, but generally what the well costs were that were authorized. Mr. Harris has already authenticated this exhibit.
Yes. So this is the well cost for each of the 8 wells. As you can see, the costs were just under $8 million a well, and the total amount for this pad of development was roughly $63 million. And these are sent out to all the partners to, elect to. It is our estimated cost for each of the individual wells.
Okay. The parties to be pooled here today, Mr. Harris said their ownership collectively is, and I'm approximating here, 0.04%. Do you know what their rough proportionate share of the well costs would have been for these two owners, or is?
Yeah, for the sum of all 8 wells, for that .042 interest, it's roughly $26,000 that SM would carry.
Okay, so SM has paid those costs on their behalf.
Yes.
Okay. XCL did not historically, and it doesn't look like, and I guess I'll ask you to confirm, XCL did not include plugging and abandonment costs in these AFEs. Is that right?
That's correct.
Do you have an estimate of what you think plugging and abandonment costs would be for these wells?
Yeah, it would be in the range of $75,000 to $100,000 per well, depending on really the wellbore conditions when we plug them.
Okay. Now the last exhibit I want you to talk about is Exhibit 11. Can you tell the board what this is? Oh gosh, apologize for the
Yeah, so this exhibit shows
Wait,
all.
sorry. Do you recognize this exhibit?
Yes.
Was this prepared by you or your office?
Yes.
Okay. Thank you.
Yeah, so this exhibit shows the cost for all the rocket wells there. As you can see, the AFE amounts versus the actual costs are depicted there. In this case, things went pretty well for this pad. You can see that some of the wells are slightly over, some are slightly under the AFE cost, but for the most part, pretty close to the planned 62.9 million. And the actual cost came in at $63.3 million. So that's a pretty small amount, like 0.5% off. So it's pretty good, execution on this pad.
Okay. And we talked about in the prior cause, well, I guess the prior related cause with the adjoining section line wells that were pooled, the Goose 50 and Goose 70. There was a cost overrun in one of those wells. You look at a unit like this and you see, gosh, it looks like they pretty much nailed the estimates. There must not be a whole lot of risk. Can you talk about kind of generally where the risk lies in a development like this and kind of how this particular development with the Goose and Rocket wells played out?
Yeah, I mean, we like we showed that on that previous well, there was an overrun of about $3.5 million. But specifically, we have risk all the way from kind of, starting to put conductors in the ground, surface intermediate, as well as the production casing and also drilling the wells. We drill through a lot of complex faults, complex natural fractures, as well as, high pressure zones and complex geology, sometimes requiring us to sidetrack if we get out of the zone of interest that we're targeting, as well as the drilling risks that are inherent in execution of these wells. There's also risks on the completion side. We have had issues where we've had casing collapse, as well as during production long term on the wells. We've had some wells plug off and not be able to return to production. So there's a lot of risk through all that, as well as anything on the surface side. The we have pipelines and facilities out in the field. Issues could come up at either of those, any of that infrastructure.
Okay, that's really helpful. Last question before I let you go. In your expert opinion, were the costs, both the AFE costs, well, let me break it up into two. Were the AFE costs, just reasonable and a good estimate at the time they were estimates?
Yes.
And in your expert opinion, were the actual costs both reasonable and necessarily incurred, and also within a reasonable variance of the AFE costs?
Yes.
Okay. With that, I have no further questions for Mr. Peterson, subject to division or board questioning.
Division, do you have questions?
The division has no questions for this witness.
Board, do you have questions? Mr. Church.
Yes, if you could clarify for me, and maybe Mr. Harris could do this rather, if it's not yourself. So we've looked at a prior cause where we've pooled a 2,560 acre force pool, and we're looking at the south half of that in this force pooling in sections 13 and 14. Is there no need to force pool the 24 and 23 and 24, or is it because the Goodrich lease and the Larson lease were not in that 1280?
Yeah, the two unleased parties are only in, I think one of them was in section 13 and one of them was in section 14. So 23 and 24, SM Energy owns 100% of that unit, so there was no need to do a separate pooling for that.
Okay, that clarifies it for me. Thank you.
No problem.
Any further questions from the board? Back to you, Mr. Mayo.
Thank you, Madam Chair. I hope it's okay. I'm going to leave the witnesses sorted like this because I think they're done. With that, we're done presenting our case in chief, and given what I assume to be not much of a presentation, if any, by the division, I'll just close. We appreciate the division and board's flexibility. You know, things happen during this process, and no one wants to see the board process back up. But we really do try to make sure we're protective of people's rights to come in and appear and make their voices heard. But we really appreciate the division working with us to make sure that it happened as seamlessly as it did. We now believe the division's concerns raised in their response have been addressed or will be addressed by the February hearing, and we do believe that the evidence clearly demonstrates that the regulatory and statutory requirements have been met. And so we'd simply ask that the board pool as requested. Before I submit, though, it might be appropriate to move for admission of the exhibits here today. Exhibits 1 through 11 and 14 and 15.
So admitted.
Thank you. And with that, I would request the board approve as pleaded.
Division, do you have any final questions?
No final questions. Just like to state that the division is satisfied with the request and the modification of the request made today, and based on the witness's testimony, the division does not have any opposition to the RAA.
Thank you. Board, do you have any final questions? Can I get a motion? Oh, this is going to be continued again until February. Is that correct? For the final order?
That's correct.
Okay.
We're asking the board to make a vote here today, but the order will be signed next month.
Thank you. Mr. Moon.
So I move we approve this request for agency action for final signing next month.
Next month. Do I have a second?
Second.
Mr. Galecki, we'll recognize your second. All in favor, please say aye.
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 Any opposed? Motion carries, and we will see you in February.
Madam Chair, would you like me to prepare the draft order for
If
that?
you would please prepare the order for the February meeting.
Happy to. Thank you so much.
With that, we have 2 items left, but I think we're going to hold up for lunch. We'll be back in 45 minutes, do you think? Quarter to 1. Thank you. This meeting is adjourned for the interim. Thank you.
1.
We are back on the record for our afternoon session at this board meeting. We're moving on to the last two items. Docket number 9. Docket number 2025-006, cause number 470-14. In the matter of the request for agency action of Anschutz Exploration Corporation for an order establishing 4 special 1,280-acre, substantially equivalent stand-up drilling units for the production of oil, gas, and associated hydrocarbons from the lower Mancos Formation, composed of 1, Section 32, 12 South, 22, I've got a typo here. 12 South, 22 East or West? East. And Section 5, 13 South, 22 East. And Sections 8 and 17, 13 South, 22 East. And Sections 9 and 16, 12 South, 23 East. And 4, Sections 27 and 34, 17 South, 25 East. All SLM, Uinta County, Utah. To allow on a pilot basis the drilling and production of up to 6 long lateral horizontal wells on each special drilling unit so established. And now we'd like to do appearance of counsel.
Fred McDonald of counsel with Lear and Lear on behalf of petitioner Anschutz Exploration Corporation.
Division.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining. And again, I am joined by Colton Goodrich, geologist, and Regina Ecker, petroleum engineer for the division.
Thank you. Mr. McDonald.
Thank you, Madam Chair. With me today, testifying in person, are Mr. Brett Willis, the supervisor of Colorado of Utah and Utah Lands, and Mr. Adam Van Holland, who is the senior operations geologist. Also appearing virtually pursuant to the board's order in on the 16th of January are Ms. Maggie Albrecht, who is the senior staff engineer. And Mr. Vice Chair, I would ask that they be sworn in as witnesses at this time.
Mr. Walker.
Please raise your right hands. Okay. Do you solemnly swear that the testimony you're about to give is in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Yes, I do.
Okay. Thank you. The resumes of all 3 witnesses were collectively submitted as Exhibit A in this cause. If separately and individually asked about the contents of their respective resumes, the witnesses would confirm the same. Mr. Willis will be a fact witness only today. Ms. Albrecht was previously recognized by the board as an expert in petroleum engineering last October in cause number 475-10. And presuming the division has no objections, we would ask that she again be recognized as an expert in that discipline for purposes of this cause.
Division, do you have any concerns?
No objections.
Board. So accepted.
Thank you. Mr. Van Hollen will be testifying for the first time in front of this board, so we will qualify him as an expert in geologist at the commencement of his testimony.
Thank you.
I'd like to confirm that you received the supplement to Exhibit Z that we filed on Tuesday. That's simply the additional certified mailings, receipt cards, or the status of the mailings.
They've been they've been received.
All right, thank you. And finally, I will be moving for admission of the exhibits at the end of our presentation, Chief. Members of the board, Anschutz is before you today seeking approval of 4 pilot drilling units for Lower Mancos production and various lands within its Uinta County holdings. Specifically, Anschutz is requesting 2 sectional stand-up drilling units with authorization to drill and produce up to 6 long lateral horizontal wells with 660-foot setbacks from drilling unit boundaries. As stated in the request for agency action, the purpose of these pilots are to test the various depths within the lower Mancos through up to the 6 requested long lateral horizontal wells, to confirm the drainage and appropriate setbacks, to confirm that 6 wells constitutes the appropriate well density, and also to confirm the viability of field-wide development on that basis. Anschutz agrees to report back to the board and the division on the results of these pilots within 2 years, provided adequate grammar protections are maintained with respect to confidential and proprietary data. This is similar to the methodical approach that the board approved back when Newfield initiated the first long lateral horizontal well development in the Central Basin back in 2013. The board has jurisdiction over this matter pursuant to Utah Code Annotated Sections 40-6 subparagraph 3B, and 40-6-6. A copy of the request was sent certified mail to all production interest owners within each of the requested pilot drilling units, including to the School and Institutional Trust Lands Administration and the BLM Utah State and Vernal Field offices, since the oil and gas and associated hydrocarbon underlying the lands are almost entirely state and federally owned. The mailings were sent to the parties' last addresses as disclosed by the BLM, Sitla, and Uena County Realty records, as well as Anschutz internal records. Exhibit Z, as supplemented, reflects either receipt, return, or the United States Postal Service status inquiry of such mailings. Notice of the request in this hearing was also duly published in the Uena Basin Standard and the Vernal Express on January 1st, 2025, and in the Salt Lake Tribune on January 5th, 2025. On January 8th, 2025, the division filed a response to the request stating its non-opposition to its granting, presuming Anschutz meets its burden of proof at today's hearing, which we will do. No other objections or no other responses have been filed, and no other party has made a formal appearance today. With that, I'll commence my examination of Mr. Willis. Mr. Willis, would you please state your name and business address for the record?
Yes, good afternoon. My name is Brett Willis. I am the land supervisor for Anschutz Exploration Corporation of Colorado and Utah Assets. Our address is 555 17th Street, Suite 2400, Denver, Colorado 80202.
And in that capacity, are you also in charge of the land records and are familiar with these 4 pilots that issued today?
Yes, sir, I am.
All right, would you please state for the record Anschutz corporate and bonding status?
Anschutz is a Delaware corporation in good standing with its principal business of business in Denver and is duly authorized to conduct business in the state of Utah. Anschutz is duly bonded with all appropriate state of Utah agencies relevant to this cause.
And also the federal agencies, correct?
Correct.
Okay. I'm going to show you what have been marked as exhibits B through G. They're shown on the PowerPoint here. Do you recognize these exhibits?
Yes, I do.
And were they prepared by you or Anschutz personnel with your review and input?
Yes, sir, they were.
All right, turning your attention to Exhibit B, would you please explain what this shows and its relevance to today's hearing?
Sure. Exhibit B is a regional locator plat illustrating the 4 proposed pilot program spacing units. Starting in the northeast, the purple polygon there illustrates what we call the Schifrin unit. It's comprised of 1,280 acres and includes sections 27 and 34 of Township 7 South, Range 25 East. And then moving southwest from there, the burgundy polygon is what we call the Bowline DSU. It's also 1,288 net acres, which consists of sections 9 and 16 of Township 1223. And then moving west again, we have 2 Birdie units. The Birdie North is the orange polygon, which is section 32, Township 12, Range 22, and also section 5 of 1322. 1,283 net acres. And finally, the Birdie South unit is the blue polygon, also 1,280 acres, and is comprised of sections 8 and 17 of Township 1322.
All right, now turning your attention to Exhibit C, please explain what this shows.
Sure. So Exhibit C is a zoomed-in version of the Birdie North DSU. So the Birdie North DSU is comprised of both federal and state lands. Starting in section 32, this is state lease 53973, which consists of all of section 32 and is comprised of 640 acres. And then section 5 is a federal lease 093905 and is comprised of 643 acres.
Now turning your attention to Exhibit D, please explain what this shows.
Yeah, similar to Exhibit C, this is a zoomed in version again of the Birdie South DSU. All of the minerals in this particular DSU are federal minerals. Section 8 is BLM lease 093905 and amounts to 640 acres. Section 17 is BLM lease 093907, again 640 acres.
Now turning your attention to Exhibit E, please explain what this shows.
Exhibit E is our Bowline North DSU. This particular DSU actually consists of BLM state and fee minerals. So in section 9, we have BLM lease 057455, amounting to 640 acres. The state lease in section 16 is 54386, And then the balance of the 640 acres and 16 that are not state are fee minerals.
And the approximate acreage of the state lease is about 472, is that right?
That is correct.
And the fee acreage is about 167, is that right?
Yes, sir, that is correct.
Turning your attention now to Exhibit F, would you please explain what this shows?
Yes, this is our final DSU. This is the Schifrin South DSU. And this one is completely federal minerals. Section 27 is BLM lease 092713, makes up 640 acres. And then section 34 is BLM lease 092713, again, makes up 640 acres.
So it's one lease that covers both sections then?
Yes, sir.
Okay. Finally, turning your attention to Exhibit G, would you please explain what this shows and its significance to today's hearing?
Yeah, so this is a summary of Anschutz's approximate interest in each of the 4 drilling and spacing units. It's important to emphasize here that our approximate working interest is 80% in each of the 4 DSUs. And here we illustrate the gross acres of the DSU. On average, each is 1,280 acres. We also illustrate Anschutz's net acreage per DSU. And again, on average, we own a little more than 1,000 of the 1,280 acres of each DSU, making up our 80% working interest.
Okay, now I'm going to turn your attention to the certificate and supplemental certificates of service. These were prepared by my office based on information you provided. Do you recognize these documents and the names and address shown on there?
Yes, sir, I do.
And who are these parties and how are these names and addresses derived?
These are production interest owners in the 4 relevant drilling and spacing units, and we obtain the information via public records, county records, and also internal Anschutz records from divisional title opinions, abstracts.
And again, also based on SITLA and BLM records since state and federal minerals are involved?
That's correct.
All right. Exhibit Z is supplemented, as I mentioned, reflects the either the receipt or return or the inquiries based on that. One final question for you. Did you have any discussions with either the BLM or SITLA regarding this request for agency action? And if so, what was their response?
Yes, we did speak with the BLM Vernal Field Office about our application, and they indicated to us verbally that they were supportive of the application we're discussing here this morning.
All right. With that, Madam Chair, that concludes my examination. Mr. Wells?
Division, do you have questions?
Just a couple quick questions for Mr. Willis. Could we go to Exhibit B, please? Just so you can enlighten us, why did you choose where these 4 units will be?
Yeah, it's a fair question. So we have leasehold position in between the burgundy polygon and the purple polygon. So in between Boland and Schifrin, we do have leasehold position there, and we do have existing wells there. And so our desire here is to progress and advance our pilot program over the next couple of years, geographically north and southwest, outside of the existing producing wells that we have in the ground.
Okay, so these these would be in areas where you are testing the extent of how far what you already have is.
Exactly,
correct?
yes, sir.
Okay. Secondly, I think it was Exhibit G where you have the gross working interest. You indicate you have 80, or Anschutz has 80% in there. There's 20% non-op. Who is that 20% one particular party? Is it multiple parties? Could you tell me a little bit more about that?
In 3 of the 4 DSUs, it is one other entity.
Okay.
And one of the DSUs, there are a couple of different third parties in the DSU who own the balance of the 20%.
And have any of those parties expressed any support or opposition to what you're trying to do here today?
I think most of our working interest partners have been very supportive of the program, the appraisal program in the basin. We have not to date, at least to my knowledge, received any sort of negative feedback from our partners. So I can't say they've either supported or denied what we're doing, but.
All right. All right, thank you. Yeah, I mean, we haven't received anything, so it's just
Okay, good.
want to get an idea of what you're hearing on the ground.
Yes.
But other than that, yeah, thank you. No further questions.
Board, do you have any questions for this witness? Mr. Walker?
Yes. You mentioned that BLM was verbally supportive. What was Sitla's reaction? I didn't hear that. Yeah.
I don't recall having, I don't recall myself having a conversation with Sitla yet about this pilot program personally, but I certainly didn't receive an objection to this matter either. The only reason we stated or testified to the fact that we did have a conversation with the BLM because they did call us, and I did personally speak with the field office about our program, and they very specifically shared with me that they would be happy for us to mention to you all that they are in support of our program.
But Sitla has remained silent from your correspondence?
We actually engage, and we have ongoing dialogue with Sitla, and since I've been part of this team at Anschutz for the past couple of years, we've had a very constructive and mutually beneficial conversation. I just don't have, I can't recall a specific conversation about this particular matter.
And those Sitla lands are leased, right? Are they held by production or are they primary term leases?
They are primary, the lease in Bowline is primary, they're all primary term, I believe.
Okay, thank you.
Redirect, Madam Chair.
Yes.
Just clarification again, the turning back to Exhibit B and following up Mr. Haynes' question, the area in between, those are the 3 federal units that the board has previously dealt with in the matters in last fall. Is that correct?
That is correct.
Right. And secondly, again, just for clarification too, the Vernal Field Office is also in charge of the communitization agreements that would be required to communitize the federal leases with the other leases. So that's why it's important to get their support as well. All right, that concludes my redirect.
Thank you. Board, do you have any further questions? Mr. Moon?
So these are going to be horizontal wells, 2-mile horizontal wells?
Yes, sir, they will be.
What's the closest? This is pretty good step out, isn't it?
About 6 to 10 miles, perhaps.
Okay, not too far away.
Not too far, yeah. The Bowline North, so the Burgundy BSU, closest producing well could be 6 to 9 miles, something like that. And then the Purple DSU, probably the same, same range.
Okay, okay. And you are anticipating oil in these, or are they primarily gas?
Yeah, so sort of outside of my lane, but from what I hear in the office, the GOR can vary depending on where we are, within our asset block. But both, in short, both.
Okay, good.
Mr. Church?
So the closest producing wells, they are similar 2-mile long horizontal wells?
Yes, they are. We have, I believe there are 6 horizontal wells in total that are currently producing. They are all 2-mile long wells.
Are those all in the Hauptmann unit? The name I've forgotten.
No, ma'am. The name of the unit is Bonanza. There is one producing well that we have drilled in that particular unit.
Okay.
And then the other producing wells are southwest of that.
That's kind of right up against the border, kind of in the middle.
Yes, ma'am. It's so the city of Bonanza there, so just east of that 925. Basically 90% of Township 925 is the Bonanza unit. And that is where our producing horizontal well is.
Thank you. Seeing no more questions, Mr. McDonald?
Thank you, Madam Chair. With that, I'll commence my examination of Mr. Van Hollen. No, just press a button. All right, Mr. Van Hollen, would you please state your name and business address for the record?
My name is Adam Van Holland. I am a senior operations geologist for Anschutz.
Address?
555 17th Street, Denver, Colorado 80202.
And part of your duties include these 4 pilot areas, is that correct?
That is correct.
All right, since this is your first time testifying in front of the board, in addition to your resume, would you please provide just a brief outline of your education, particularly your work experience in any analogous basin or the Iona Basin, and any horizontal well development?
Sure. I have 20 years experience, 17 of that, so the vast majority unconventional horizontal type development. I have a bachelor's from Montana State University and a master's from the University of Wyoming, both in geology. I have worked the Piceance Basin multiple times, first for what was Encana at the time, and I've worked that for Anschutz also, and I have worked the Uinta Basin for Anschutz since 2019. I'm also certified licensed professional geologist in the state of Wyoming, and have been qualified as an expert witness before the Wyoming Oil and Gas Commission.
Madam Chair, with that testimony and his resume, I would ask that the board recognize Mr. Van Hollen as an expert in geology for purposes of this cause.
Divish, do you have any questions?
We have no questions for Mr. Van Hollen, and based on his resume, we're happy to accept him as an expert.
Board, do you have questions for this person? He is accepted as an expert witness.
Thank you, Madam Chair. Mr. Van Hollen, I'm going to show you what have been marked as exhibits H, I, J, and K. Do you recognize these exhibits?
I do.
And were they prepared by you or Anschutz personnel with your review and input?
Yes, they were.
All right, turning your attention to Exhibit H, would you please explain what this shows and its significance to today's hearing?
Exhibit H is showing a subsea structure depth for the Lower Mancos Formation across the lands in question and surrounding areas. As there is a 100-foot contour interval on the map, and the structure generally dips to the north and northwest in about 2 to 4 degrees of kind of regional dip, again to the northwest. Also annotated on the map are the cross-section lines that will be in further exhibits, A to A prime and B to B prime, and with the proposed drilling units highlighted as well.
Right, and the blue dots represent control points, is that
The
correct?
blue dots are wells that were drilled deep enough to have a Lower Mancos penetration.
Now, turning your attention to Exhibit I, would you please explain what this shows and its significance to today's hearing?
Exhibit I is the isopack thickness map of the Lower Mancos Formation. This also is made with a 100-foot contour interval. What we're seeing here is that across the lands, the Birdie Bowling area will be expecting to have between 2,600 and 2,700 feet of Lower Mancos. And then at the Schifrin area, the Mancos Formation thickens, and we expect on the order of 3,500 feet of Lower Mancos thickness in that area. Between the structural map and the isopack mapping, these show that the formation is present and continuous underneath our lands.
Now, turning your attention to Exhibit J, would you please explain what this shows and its significance to today's hearing?
Exhibit J is a type log for the Lower Mancos Formation, and we're showing the interval defined as 7,745 feet down to 10,420 feet. This is a type log, for the Torreys Federal well. I'm not going to read the header and all that. We can all read that on our own, but this Torreys Federal is our type log, and I'm annotating here the section as it's described.
And this is one of the wells that's shown on that cross-section.
That's correct. We'll see that they'll marked on the cross-section.
Right. Speaking of, turning to Exhibit K, would you please explain what this shows?
Exhibit K has two different cross sections. On the left, we'll see A to A prime. This is through the Birdie and the bowling unit area. I have annotated the type well there on the right side of the cross section. And again, the purpose of this cross-section for today's hearing is to show that this formation is continuous and present underneath the lands and that it is correlatable across the area.
All right, is it your expert opinion then that the lower Mancos constitutes a common source of supply in each of the drilling units at question?
Yes, it is.
Is it also your expert opinion that the continuity of the lower Mancos through each drilling unit make it attractive for long lateral horizontal well development?
Yes, it is.
Madam Chair, that concludes my examination of Mr. Van Holland.
Division, do you have questions?
Just one geological question. So the request today is for the Lower Mancos interval. Does the geology of the Lower Mancos justify development would be limited to that interval?
Are you speaking of limited to this 2,600 foot interval?
Yeah, like permeability wise. I mean, if you're going to be testing in there, do you know that you're not going to go outside of the interval that's being requested today?
I believe I can say that you know we're in this 2,600 foot interval is where we're going to be developing our wells.
All right, thank you.
Board, do you have questions for this witness? Mr. Church.
Yes, you're going in for stand-up units. Do you have a regional stress map that?
That'll be the next witness, Mr. Church.
Oh, the next witness is going to be on. Okay, and so, and within this 2,600 foot interval, you have some specific targets at this time, is that correct?
We do have targets identified that we plan to, the whole purpose here is to evaluate multiple potential benches and targets within this large, thick interval. So yes, we have done the analysis and do have a high-graded list of potential targets within the larger interval.
Thank you.
Please proceed, Mr. McDonald.
Thank you, Madam Chair. With that, I'll commence my examination of Ms. Albrecht, excuse me. Thank you. Ms. Albrecht, would you please state your name and business address for the record?
Yes, can you hear me?
Yes.
Great. My name is Maggie Albrecht, and my business address is 555 17th Street, Suite 2400, Denver, Colorado, 80202.
And what is your current position with Anschutz, and how does it relate to these 4 drilling units at issue?
I'm a senior staff reservoir engineer working AEC's assets here in the Uinta Basin, including in the areas proposed by these pilots.
All right, Ms. Albrecht, I'm going to ask you to refer to exhibits L and M. I don't know if you can see the PowerPoint through the presentation, but if you have those exhibits in front of you, were they prepared by you or Anschutz personnel with your review and input?
Yes, they were.
All right, turning your attention to exhibit L, would you please explain what this shows and its significance to today's hearing?
So the upper map shows, similar to prior exhibits, the 4 drilling spacing units that we're talking about here in this hearing today. And the yellow star indicates the location of the Torrey's federal pilot, and in relation to the proposed drilling spacing units that we're discussing. And the kind of golden arrows are indicating the direction of SH max. So the direction that we expect that hydraulic fractures to propagate. And this is based off of information published by Lund, Snee, and Zobak in an AAPG bulletin indicated down at the bottom, where in the same area, the Torrey's fed well is pictured once again in the yellow star with the black lines, black and blue lines indicating the directions of the maximum horizontal stress direction, or the direction that we anticipate hydraulic fractures to propagate, indicating that stand-up DSUs are what are needed to prevent waste and maximize recovery.
Again, because you want to intersect these fractures perpendicularly to maximize the production, is that correct?
That is correct.
All right. Now turning your attention to Exhibit M, there's quite a bit of information on here. If you would please explain what it shows and its significance to the proposed pilots.
Yes, the map on the upper left is an example drilling spacing unit of the area of the Birdie South. And shown within that blue unit, we're depicting 6 potential well bores that honor the 660-foot setbacks within this unit. And in a more gun barrel view shown on the right, so here we're now depicting that map view of 1 mile thickness and 1 mile east-west, 2 miles north-south. So of a gun barrel view of that stand-up unit, where we're proposing within that 2,700 to 3,600 foot variation in thickness of the lower Mancos, proposing 6 potential wells within this thickness that would exceed the 100 feet requirement of different tests, different vertical tests within that spacing unit. And in the bottom right-hand portion of this diagram, you see a table where we're calculating in-place gas volumes and assuming a recovery factor of 6%, consistent with the petrophysical properties that have previously been shared of the lower Mancos using the Torreys well, and once again coming up with potential recoverable gas volumes and demonstrating using 6 wells to try to drain these volumes will result in economic recovery within this 2,700 to 3,600 foot variation in thickness across these intervals. And based on these estimated parameters, we think that 6 wells per drilling spacing unit is economically justified for our pilot spacing purposes.
Okay, then is it your expert opinion that a stand-up drilling unit orientation should allow for intersections with fractures perpendicularly and therefore increase the success for prolific production?
Yes, that is my expert opinion.
Okay, is it also your expert opinion that up to 6 long lateral horizontal wells may be necessary to maximize economic recovery from the lower Mancos based on the data that you have today?
Yes, based on the data we have today, that is my expert recommendation.
Is it also your expert opinion that 660-foot setbacks from the drilling unit boundaries with more than 1,600 feet of lateral and 100 feet of vertical separation should prevent waste?
Yes, that is my opinion.
And finally, is it your expert opinion that the pilot results will help confirm these preliminary conclusions and will determine if field-wide development is justified?
Yes.
With that, Madam Chair, that concludes my examination. Ms. Albrecht.
Thank you, Division.
The division has no questions for this witness.
Board, do you have questions? Mr. Church.
Maybe this would go to Mr. Van Hollen, but I'm not sure. So the production out here that we've looked for in the basin is sourced by lake sediments. The Mancos, however, is a marine type sediment. So do we have comparable TOCs in the Mancos as we have up in the other producing formations?
So the TOC in the Mancos varies from 1 to 3% across the board. As far as comparing that to some of the production out of the Green River and Wasatch, sir, I don't have those numbers and can't compare to what the Green River is, but I can tell you that our TOC in the lower Mancos generally varies between 1 to 3%.
But the producing wells that are economic, that have already been drilled, they indicate that it's internally sourced from the Mancos. Is that correct?
Correct.
Okay, we're going for 4 units here initially rather than just 1 or 2. So you feel that with the existing production that we already see, that it justifies going into a 4 spaced unit pilot program?
Yes, sir, I do.
Okay, thank you.
Board, do you have any further questions? Seeing none, let's proceed.
Thank you, Madam Chair. With that, that concludes our presentation in chief. At this time, I would move for admission of Exhibits A through M and Z as supplemented.
So admitted.
Any objection from the division?
Oh, I'm
No
sorry.
objection, no.
Okay.
So
All right,
admitted.
Thank you, Madam Chair. With that, I'll reserve my closing remarks after the division's presentation.
Okay. Division.
Thank you. The division spent some time reviewing this request and went through the exhibits. The division has no opposition to what Anschutz, the petitioner, is asking for here today, specifically with the requested setbacks of 660 feet. The division feels like that will be protective of correlative rights in the area without more information being known. That is a good setback to allow them to test that and protect those rights. So with that in mind, and based on the testimony here today, the division has no opposition to this request.
Thank you. Board, do you have further questions? Mr. Church.
I neglected to ask this earlier. The existing producing wells that are economic, what do they IP at, and what is their sustained production, do you estimate?
I'm not prepared to answer that one. I would defer. Can I defer and speak with counsel?
Ms. Albrecht, would you be able to answer that question?
Yes, I would say that production, IPs, but then it also declines over time. And it is my understanding that this is publicly available information.
Okay, but right offhand, you don't have that information.
I would say there's a range of initial production between, are you asking gas production?
No, oil and gas. I'm also looking at what is oil and what is gas. How much gas will there be compared to the oil?
Yeah, I would say that is going to range areally. But we have seen IPs between, 3 and 10 million cubic feet per day, as well as IPs, with associated liquids, between 700 and 1,000 barrels of oil per day.
Okay, so there is infrastructure out here to take away the gas without a large investment. Is that true?
Right now, there is infrastructure for gas takeaway. Additional infrastructure may be needed.
I believe there's gas lines to the Bonanza unit, aren't there? That Houtman property. Weren't there gas lines that were laid? Do you know?
Brett, do you know? Come on up.
Yeah, there are gas lines to the Bierstadt well, as well as the Torrey's well.
Okay.
Yeah, all of our wells are connected to a gas pipeline currently, and so we do have right now, with all the wells that are in the ground, enough capacity to have gas takeaway. But like Maggie said, we will probably require additional capital for additional build outs so long as we continue appraising this particular block of acreage.
So on your appraisal plans, will you be coming in and doing just one well, or will you be doing 4 wells in the program?
I think it depends. I think, ideally, we would like to drill more than 1 well per pad, as we continue to appraise the property and learn more over the next handful of years. I think that there's opportunity to drill more than 1 well from a single pad.
Right, but as far as the 4 different units, you're not going to come in and do all 4 units at once?
We would very likely, I would guess, we'd very likely appraise 1 unit, with 1 to 6 wells, and then go appraise another unit with 1 to 6 wells, take those learnings, and then apply them to the next subsequent 2 DSUs.
Okay, thank you.
Yes, sir.
How many producing wells out in this area does Anschutz operate?
I believe the total count is 6.
Okay.
Yeah.
Between the
first-
northernmost and the southernmost.
Yes, ma'am. So the first 2 wells came on the fall of 23, I believe. And then last year, the year of 2024, we turned on an additional 4 wells. So we're at 6. It's taken, 2 years for 6 wells to come on. But, at this rate and with all of the learnings from Uinta and then some of the powder learnings that we can apply to the Uinta, hopefully the development can accelerate.
And you're trying to establish some exterior boundaries for these.
Exactly.
production
Yeah.
aerial
And
extent.
also, have an inventory of permits. The permitting process we have found is quite, it just takes a long time when we're dealing with federal lands. And so this really is going to enable us to, put together, upwards of more than 20 permits basically, and have these in our inventory as possible realistic and feasible locations to go to and appraise.
Thank you. Board, do you have more questions? Back to you, Mr. McDonald.
Thank you, Madam Chair. Again, the approach here is a pilot program. The idea is to learn more about this, the extent, the well density, the setbacks appropriate. It's a systematic approach. It's the same approach that Newfield took and the board approved and I think appreciated that step by step. And then the idea would be is based on the data and hopefully with success that they will come back on a larger basis with you with the supporting data to do that. Keeping that in mind, again, I believe that we've met all the statutory and regulatory requirements for granting the request. We would ask that the board do so. We thank you for your time and attention. And again, particularly the IT group for allowing for Ms. Albrecht to testify virtually today. Thank you.
Thank you. Division, do you have any final thoughts?
No additional comments, no.
Board, do we need to deliberate or are we ready to look at a motion? Are we ready to? Yes. Okay. Could I get a motion from the board?
I move that we approve this request for agency action.
And a second?
Second that.
It's been moved and seconded. All in favor, please say aye.
Aye.
Any opposed? Motion passes.
I'll be happy to prepare an order and submit it to council.
Thank you. Tell me when you're ready, Mr. McDonald. Do you have any witnesses for this final?
Yes, they're both virtual, and I believe they're both there. It appears that they're both ready to go.
Okay. We're moving on to item number 10. Docket number 2025-007, cause number 470-15. In the matter of the request for agency action of Uinta Wax Operating, LLC, for an order modifying and partially vacating the board's order entered in cause number 470-07 to 1, reestablish the drilling units for production of oil, gas, and associated hydrocarbon from the lower Green River Wasatch formations through long lateral horizontal wells comprised of all of sections 11 and 14, 14 south, 22 east, and B, section 2, 4 south, 2 east, and section 35, 3 south, 2 east, all USM, and C, sections 23 and 26, 3 south, 2 east, USM, as originally provided under the board's order entered in cause number 131-151, and 2, eliminate the drilling unit boundary well drilling units and any special drilling units established thereunder, inclusive of said lands to the extent inconsistent with the foregoing. All lands located in Uinta County, Utah. Mr. McDonald.
Yes, Fred McDonald of Counsel with Lear & Lear on behalf of petitioner Uinta Wax Operating, LLC.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining, also joined by Colton Goodridge, geologist, and Regina Echo, petroleum engineer for the division.
Thank you. Back to you, Mr. McDonald.
Thank you, Madam Chair. Appearing today on behalf of Uinta Wax, virtually pursuant to the board's order entered yesterday, are Mr. Herschel Sanders, who's the landman of Uinta Wax LLC, and Ms. Kayleen Bridwell, who's the Senior Engineer ESG Advisor of Uinta Wax LLC. That entity shares duties with the petitioner as well. And Mr. Vice Chair, I would ask that they be sworn in at this time.
Please raise your right hands. Okay. Do you solemnly swear that the testimony you are about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Herschel, I believe you're on mute.
I do. There we go. Thank you.
All right, thank you. The resumes of both witnesses were collectively submitted as Exhibit A. If asked, each would confirm the information reflected in those resumes is true and correct. Mr. Saunders will be testifying as a fact witness only. Ms. Bridwell has previously been recognized by the board as an expert in reservoir engineering. Based upon her resume and that previous recognition, and presuming the division has no objection, we again request that she be recognized as an expert in that discipline for purposes of this cause.
No objection by the division.
Seeing no objection, she is so accepted.
Thank you, Madam Chair. And also, I will again be moving for admission of my exhibits at the end of our presentation in chief. Members of the board, as the board may recall, almost a year ago, in cause number 470-07, Uinta Wax had requested reorientation of several long lateral horizontal well drilling units within Township 3 and 4 South, Ranges 2 and 3 East in Uinta County, as well as establishment of associated drilling unit boundary well drilling units, which the board granted. Specifically as to certain lands in Township 3 South, Range 2 East, Uinta Wax had requested reoriented two-sectional, and due to the Uinta Special Meridian, certain 3 partial section drilling units for long lateral wells, along with associated drilling unit boundary well drilling units. And as to the lands in 4 South, 2 East, they were 1.5 section drilling units for long lateral wells, along with associated drilling unit boundary well drilling units, all in the effort to make the spacing more uniform, as well as to space previously unspaced lands in accordance with the more uniform spacing pattern. A true and correct copy of the 470-070 order was submitted as Exhibit B in this cause. I do want to point out the typo in the request for agency action stated that was May 16, 2024, when in fact it's March 16, 2024. However, based on the drilling to date, it appears that 2-mile-long lateral horizontal wells provide a better economic return. Also, that it's more feasibly, and the technical concerns that were expressed for the shorter laterals has turned out not to be the case. Uinta Wax has therefore reconsidered its development plans for this area to drill 2-mile-long lateral wells instead of the 1.5-mile-long lateral wells. To start, it is requesting modification of the 470-070 order to reorient and instead establish drilling units comprised of, first, sections 11 and 14 of Township 3 South, Range 2 East. Second, sections 23 and 22nd of Township 3 South, 2 East. And finally, Section 5 of Township 3 South, 2 East, and Section 2 of Township 4 South, 2 East. The same caveats regarding well density, setbacks, etc., as set forth in the 470-07 order will still apply. This request, however, will also require the elimination of the drilling units established under the 470-07 order, comprised of Sections 11, 14, and 23 in Township 3 South, 2 East, and of the associated drilling unit boundary wells inclusive of those lands, since they'll be off pattern. No wells as authorized under the 470-07 order have been drilled yet on any of the affected lands. Therefore, the requested relief will not have any adverse effect on rights that have occurred since that order was entered. If this phase is successful, Uinta Wax will seek similar board approval as to all the remaining 470-07 lands. The board has jurisdiction over this matter pursuant to Utah Code annotated sections 40-6-5, subparagraph 3B, and 40-6-6. Notice was sent via regular mail to all production interest owners in the affected lands, including the Ute Tribe, the Ute Distribution Corporation, the Bureau of Indian Affairs, and the Vernal Field Office of the BLM, which serves as technical advisor to the BIA due to the Indian ownership. The mailings were sent to these parties at their last addresses disclosed by the relevant Uinta County and BIA records and UNOWAC's internal land records. The record will also reflect that notice was duly published in the Uinta Basin Standard and the Vernal Express on January 1st, 2025, and in the Salt Lake Tribune on January 5th, 2025. On January 8th, 2025, the division timely filed a response to the request for agency action, stating that the division does not oppose the granting of relief, presuming UNOWAC meets its burden of proof at this hearing. As today's testimony will reflect, UNOWAC will sustain that burden. No other objections or responses were received. With that, I'll commence my examination of Mr. Sanders. Mr. Sanders, would you please state your name and business address for the record?
Herschel Sanders, 6000 Western Place, Suite 1000, Fort Worth, Texas, 76107.
And what is your current position with UNOWAC LLC, and how does it relate to the lands at issue today?
I'm a landman for UNOWAC and currently working on the areas at issue.
All right, would you please state for the record the corporate and bonding status of UNOWAC Operating LLC?
UNOWAC Operating is a Delaware limited liability corporation. It's in good standing with all its principal place of business in Fort Worth, Texas. UNOWAC is duly authorized to conduct business in the state of Utah and is fully bonded with all relevant state of Utah and federal agencies. It's the designated operator on behalf of UNOWAC LLC.
Thank you. Now, I'm hoping you have either can see the PowerPoint or you have these exhibits in front of you. I'm going to direct your attention to exhibits C through H for purposes of this cause. Do you recognize these exhibits?
I do.
And were they prepared by you or UNOWAC personnel with your review and input?
Yes, they were.
All right, would you please turn your attention to Exhibit C and explain what this shows?
I'm going to look at mine instead of your small copy there. Exhibit C is simply a regional locator plat showing the area at issue being just southeast of the Randlet town site, about 4 miles southeast.
Okay, turning your attention now to Exhibit D, would you please explain to the board what this shows?
Exhibit D is the current DSU layout that was a result of the 47007, showing the 11, 14, 23 DSU and then the ones going south.
All right, and just for the board's information, Section 11, the red line inadvertently crosses there, but it includes Section 11 as well, that top drilling unit. That's the current status.
That is correct. The plat, and we can get that one changed for you. It left 11 off of that, but 11, 14, and 23 is an existing DSU.
And that's because of the UN Special Meridian line that they're partial sections. Is that correct?
That is correct.
All right, now turning your attention to Exhibit E, would you please explain what this shows?
Exhibit E is the drilling unit boundary well DSUs that were created as a result of the 47007. These will have to be looked at in this issue due to the change in the offsets.
And by that, we mean that we're going to eliminate them at this time because they'll be offsetting than what was set under the 47007 order. Is that correct?
That's correct.
All right. Now turning your attention to Exhibit F, would you please explain what this shows?
Exhibit F is the new DSUs that we're currently requesting under this hearing today, and it would basically go back to what it was.
And this would require elimination of sections 11 and 14 from that special drilling unit that was previously under the 470 order. That's correct?
That is correct.
All right. And so these now would establish, again, 2-mile drilling units for long lateral horizontal well development.
For those down there where it was switched to a 1.5 miles, it will go back to a 2 mile.
Okay. Now turning your attention to Exhibit G, would you please explain what this shows?
Exhibit G shows the offsetting wells to the lands at issue, and it also shows the one long lateral well that is currently on the lands at issue in the 35-2 DSU. That production was set to stay in that DSU under the 47007 order. So nothing will change there. It will go back to like it was, even though that did not change.
Okay, so just for clarification again, so that well was drilled under the old order. The drilling unit was modified under the 47007 order, except that specific well was to stay on the previous drilling unit basis. Is that correct?
That is correct. We have drilled no wells under the 47007 order. That well was already there.
So this simply is going back to the status before this 47007 order was in place anyways.
That's correct.
All right, thank you. All right, now I'm going to turn your attention to Exhibit H. Would you please explain what this shows?
Exhibit H is the green outline on Exhibit H is the area of notice that we notified for this cause.
And that would be all the production interest owners in those areas, since these are drilling units that are now being affected by your request.
That's correct. We notified all production interest owners within the green outline.
All right, so I'm going to ask you to refer to the certificate and supplemental certificate of service. You should have those in front of you. Those are pleadings that were prepared by my office with information that your office supplied. Do you recognize the names and addresses that are shown on those documents, those pleadings?
I do.
And who are those parties?
These parties are all production interest owners that are outlined in the Exhibit H.
The green outline?
Yes, sir.
All right, and how were those names and addresses derived?
They were derived out of using Uinta Wax's internal land records, including title opinions, where we had those, and a search of Uinta County and BIA records.
All right, with that, Madam Chair, that concludes my examination of Mr. Sanders.
Division?
Just one question. So if we're eliminating the Section 11, 14, and 23 unit, so will Section 11 and 14 no longer be under an order?
Yes, that's correct.
All right. Yeah, we have no further questions.
So are those partial sections orphaned then? Will they ever be included?
I think the intent is that once they determine here on this 2 mile, what they will do is come back and work with that. But they won't necessarily be orphaned. They may drill on a vertical basis. Remember, these are overlapping drilling units here. We're just talking about the long lateral horizontal wells.
Okay. Did you have any other questions, Mr. Haynes? Board, do you have any questions? Seeing none, let's move along.
Thank you, Madam Chair. With that, I'll commence my examination, Ms. Bridwell. Ms. Bridwell, would you please state your name and business address for the record?
Yes, Kayleen Bridwell, 6000 Western Place, Suite 1000 in Fort Worth, Texas.
All right, Kayleen, would you please turn on your camera?
I have it on, and for whatever reason, it's not showing.
All right.
I don't know. I'm having technical difficulties with that. It worked a minute ago.
Okay.
I apologize.
All right. Is that okay with you, Madam Chair, as long as you can hear her testimony?
Okay. We'll accept that.
All right, thank you.
I'm so sorry.
That's fine. Would you please state your position then with Uinta Wax, and how does it relate to today's hearing?
Yes, I'm a senior engineer, mostly reservoir, and also an environmental advisor at Uinta Wax over the subject area that we're talking about today.
All right. I'm going to ask you to turn your attention to Exhibit I. I presume you have that in front of you, or if you can at least see it on the PowerPoint. Would you
Yes.
please explain to the board what this shows and its significance to today's hearing?
Yes, so this map and then the explanations next to it show that there is a mix of offset wells from 1 mile, 1.5 mile, and 2 mile lateral lengths. But only a 2 mile lateral exists in the application lands. Our original thinking here when we switched it to 1.5 miles would be that there's a mechanical risk because this area is shallower, but in the last year that has been proven to not be an issue. So there's no more concern on the mechanical side. And then what we wanted to show is that drilling a 2 mile lateral optimizes costs and it improves our economics by maximizing reserves recovered and limiting surface footprint. And that this allows for optimal flexibility and spacing to maximize recovery and preventing waste.
All right, so again, with a 2 mile, you have less of a surface input than you would with drilling all the 1.5 miles?
Correct. You would have less pads and less of a footprint on the surface.
And the economic benefit of drilling a 2 mile outweighs the whatever additional cost it might be to drill that additional half mile, is that correct?
Correct.
All right. Was there any discussions with the Vernal Field Office regarding this request? And if so, could you advise the board what those were?
Yes, there was, and that they had no objections to this request.
All right. And again, they serve as the technical consultant to the tribe. Is that correct?
Correct.
All right. Is it your expert opinion then that 2 mile long lateral horizontal wells in this area are mechanically sound to drill, will provide less impact, and provide a better economic return than 1.5 mile long lateral wells?
Yes, that is my opinion.
Is it also the company's position that if this proves successful, then you may take it on a larger basis to the area that's shown under the 47007 order?
Yes, that's correct.
All right, thank you. Madam Chair, that concludes my examination. Ms. Bridwell.
Division?
Division has no questions for this witness.
Board, do you have questions? Are these lands all federal or are they tribal?
Mr. Saunders, are you still on?
Yes, it's a combination of tribal and allotted and fee. There is no federal in these lands.
Thank you. Seeing no other questions, please proceed, Mr. McDonald.
Thank you, Madam Chair. That concludes our presentation in chief. At this time, I would move for admission of Exhibits A through I inclusive.
And you have a plat showing where the interested parties, you're not submitting the certificates of service.
That's part of Exhibit G, or excuse me.
H?
H.
Okay.
Yep.
So admitted. Thank you.
Any objection from the division?
No.
All right, thank you.
So admitted.
All right, with that, I'll reserve my comments until after the division makes its position stated.
Thank you. Division.
Thank you. After the division reviewed this request, the division has no opposition for an operator wanting to drill 2 mile laterals, and if that's their business plan, we're fully in support of that. And so with that, we have no opposition to modifying or partially vacating the previous order for these lands.
So let me be clear. 47007 still applies to 11 and 14. Is that true?
No, it's being eliminated as a long lateral drilling unit along with Section 23.
Okay. Board, do you have any questions?
I do.
Mr. Church.
So we talked about 11 and 14 being orphaned, and we hear that 3 mile laterals are taking place in some places. Is this area too shallow to consider a future 3 mile lateral that may drain the resource in 11 and 14?
Ms. Bridwell, do you want to answer that?
Yes, thank you for your question. As of right now, when I think that it's too shallow in this particular area for us to attempt a 3-mile lateral here. We just got comfortable with going over 1.5 miles.
Okay, thank you.
Board, do you have any further questions? Back to you, Mr. McDonald.
Thank you, Madam Chair. With that, again, we thank you for your time and attention. We believe that the statutory and regulatory requirements have been satisfied. Again, this is testing out this program, but again, if it proves as what UNOX suspects, we will be back in front of you seeking a larger approach to this area. Again, we also thank the IT team for allowing Ms. Bridwell and Mr. Saunders' appearance by virtual, and we ask that you approve the request as submitted.
Board, do we need deliberation time, or are we ready to make a motion? Are we good to make a motion? Can I get a motion on this matter? Mr. Galecki?
I move that we approve the request for agency action as presented.
And a second, please. Second. It's been moved and seconded. All in favor, please say aye.
Aye.
Any opposed? The motion carries.
Thank you, Madam Chair, and I'll prepare the order and submit it to council.
Thank you. And with that, I believe we are about to be adjourned. Do I have a motion to adjourn?
I'll make a motion to adjourn.
We are we are moved and adjourned. Thank you.